Okay, ladies and gentlemen, thank you for your patience and welcome to the February board meeting of the Toronto Police Services Board. The meeting is properly constituted and I call it to order. Let me ask first if there are any declarations of interest to my colleagues under the Municipal Conflict of Interest Act.
It's not a conflict. I just want to acknowledge that there are several of my colleagues from the mental health sector here today on the deputations list.
Colleagues, hearing none, thank you. Before I get on with the regular portion of the meeting, I want to read a statement on behalf of the entire board regarding Chief Mark Saunders. This is a statement that the board wishes to make unanimously, and the board fully and unequivocally supports Chief Saunders. The board stands behind Chief Saunders. The board will continue to work with Chief Saunders to ensure that the Toronto Police Service is and continues to be an organization of excellence and an organization committed to positive change and growth, and Toronto's continued status as one of the safest big cities in the world. We know that modernization of our police service is necessary. We also know that it is difficult. We are keenly aware of the challenges this substantial change poses for our members, both uniform and civilian, as well as for their families. But we also believe that the organization will emerge from this transformation stronger, more effective, and more responsive to and trusted by the community. We believe, too, that it will ultimately be a better place to work for all of our members. We want our members to be meaningfully invested in transformation, voicing their opinions and suggestions throughout in a constructive way. This has always been our position, and this has not changed. We know that the strength of the Toronto Police Service is in the men and women who day in and day out work tirelessly and with dedication to keep our city safe. We are entirely committed to ensuring the safety and well-being of our officers, consistent with the wishes of their family members. We understand that the Toronto Police Association strongly prefers the status quo. The TPA has been invited to the table, and we have sought its input from the outset. Notwithstanding this reluctance to help bring about the necessary change and modernization, we continue to seek opportunities to work constructively with the TPA and with the men and women of the Toronto Police Service in the cause of transforming and modernizing the service itself and policing in our city. The committed participation of the TPA in that process is, in our view, a more constructive approach to ensure consideration of the concerns of police officers than the actions that this vote today, which we believe really achieves no positive results. So that is, again, a unanimous statement on behalf of the Toronto Police Services Board. Thank you. I would now like to go through the agenda and ask for confirmation of the minutes of the meeting held on January the 18th, 2018. Motion to Mayor Tory, seconded. Councillor Lee. Item number 5, there is a presentation, so we will hold. Item number 6, the same thing. Item number 7. 7.1, item number 8. There is again a deputation. Item number 9 is the quarterly report occupational health and safety update, October 1st, 2017 to December 31st. Motion to receive. Councillor Lee, second. Mayor Tory, all in favor? Any contrary? Thank you. Item number 10, there's a deputation as well. Item number 11 is the 2017 secondment list. Motion to receive. Mayor Tory, seconded. Mr. Jeffers, all in favor? Any contrary? Carried. Thank you. Item number 12 is the annual report of the 2017 uniform promotions. Motion to receive. Councillor Lee, seconded Councillor Carroll. All in favor? Any contrary? Thank you. Item number 13 is the annual report 2017 summary of grievances. Motion to receive. Councillor Lee, seconded Ms. Santa Casera. All in favor? Any contrary? Thank you. Items for consideration, item number 14, there is a deputation. Same with item number 15 and 16. Item number 17 is the annual report, Freedom of Information. Is there a deputation on this? There is, okay. Yes. 16, okay, we'll hold that for a deputation. Item number 17, special constable appointments for February 2018. Motion to approve. Mayor Tory, Ms. Santa Casera, all in favor? Any contrary? Thank you. Number 18 is the Environics Analytics vendor of record. Motion to approve. Councillor Lee, seconded. Mr. Jeffers, all in favor? Any contrary? Thank you. Item number 19, nomination of a member to sit on FPAC. Motion to approve. Councillor Lee, Ms. Santa Casera, all in favor? Any contrary? Thank you. There is item number 20, the motion to receive the appointment of special constables to direct traffic. Are there any deputations on it? No. So is this correspondence, so motion to receive? Mayor Tory and Councillor Lee, all in favor? Any contrary? And there's a new piece of business, item 21, which we'll hold. Mayor Tory, you have something you want to bring forward. So thank you very much. The first item of business is, I'm coming back to that, is item number 4, which is the reappointment of board member Marie Molnar. And we're delighted that Ms. Molnar has agreed to stand. She unfortunately is not here today, but there are, I gather, several deputations to hear. And the first one is Derek Moran. Derek, you know the rules?
I just want to say about me speaking at this meeting, which didn't be in any way my consent, expressed my pride as an actual God, God bless Her Majesty the Queen, and long live Her Majesty the Queen. You know, I just left Brenda Ross here gobsmacked. She did not know before I informed her that Marie Molnar is actually a lawyer, so now she knows. So this is from the Law Society of Upper Canada Lawyer and Paralegal Directory. It says that Marie Elaine Ramon Molnar is not practicing law, which is good because that means she's not out there harming people for money by attorning her fellow man, woman to the government as a ward of the court, as a ward of the court is defined in Black's Law Dictionary, 4th edition, as infants and persons of unsound mind placed by the court under the care of a guardian, and their rights must be guarded jealously. So take notice, these are excerpts that I need to know Marie Molnar as a lawyer knows in order to be a trustee of the public's interest as a member of this board. And these are from Henry Gibson's Suits and Chancery text. No man, or in this case woman, can ever become an accomplished lawyer unless he fully masters the leading maxims of the law and makes them entirely his own. They constitute no inconsiderable portion of the technical nomenclature of jurisprudence, and a thorough understanding of them is indispensable to a lawyer's education. They contain not only the very quintessence of law and equity of good reason and good conscience, but they also greatly tend to broaden the comprehension and strengthen the apprehension of legal and equitable principles. No lawyer can readily understand much of the very best legal reasoning found in the reports and treatises, unless he understands the meaning and scope of the maxims found therein. These maxims are not, as some ignorantly affect to believe, mere ostentatious displays of pedantic lore, but on the other hand, they are the very fountains out of which the science of jurisprudence flows, and the sources of all that is beautiful, majestic, and divine in either law or equity. Without the maxims, The law would be an interminable medley of disconnected cases which no memory could hold. But great minds, by compressing multitudes of individual cases, have obtained therefrom their essence, as it were, the logic of the rulings, the rationale of the adjudication. This is Latin here, the rationes decidendi, the very laws that govern the laws, the lege leflam. And this is the origin of maxims, by whose aid order took the place of confusion, system marshaled the cases into harmonious ranks, the law became a science, and a jurisprudence a philosophy. It is impossible for a solicitor to find a precedent for every case, even if it existed. But he who has the maxims mastered is saved much of the drudgery of hunting precedents. So out of a few fundamental maxims can be deduced the rules by which proper application will determine the equities of the vast proportion of equitable suits instituted in chancery. Milius est pater fontes quam sectari rivalus. It is better to seek the fountains, the maxims of the law, than to follow the rivers, hunt for adjudications based on maxims, case law. So I have some maxims that I brought today. One of them is an equal has no power over an equal. All men, and women too, are equal as far as the natural law is concerned. Man, homo, that's Latin, I'm not saying, man, homo is a term of nature, person, persona of civil law. And because the very beginning of the Constitution starts off about recognizing the supremacy of God, Romans 2:11 here says, for there is no respect of persons with God. And I just want to point out the sign that Marianne Wright pointed out to Justice Copeland on Tuesday on the front door of police headquarters here refers to a person, which is defined as Her Majesty and an organization in the Criminal Code and a corporation in the Legislation Act of Ontario. And Luke 11:52, woe unto you lawyers, for ye have taken away the key of knowledge. Ye entered not in yourselves, and them that were entering in ye hindered. Luke 16:13, no servant can serve two masters, for either he will hate the one and love the other, or else he will hold to the one and despise the other. Ye cannot serve God and mammon is the god of riches. Luke 11:46, and he said, woe unto also ye lawyers again, for ye laid men with burdens grievous to be borne, and ye yourselves touch not the burdens with one of your fingers.
Thank you, Derek. Any questions of Derek? Okay, thank you very much. Next is Desmond Cole. Okay, if Desmond's not here, that is the depositions. So with that, any comment, colleagues? If not, a motion to receive. Councillor Lee, seconded Ms. Santa-Casera. All in favor? Any contrary? Thank you. Item number 5 is an update of the interim steering committee, and I'm delighted that Natisha Massagoy, who has agreed to help us, is here to give us a very quick update on the work she's been doing. Natisha, thank you.
Thank you, Chair Pringle. My name is Natisha Massagoy, and I'll be providing a brief update on the work of the interim steering committee since the last report. But before I start, I'd like to just state for the record that I understand the magnitude of the task at hand for the steering committee. And I also understand that it's going to be a difficult process, as well as one that is going to require an enormous amount of patience, as well as time. I also want to emphasize that this is just as much a trust-building exercise that we're going to be undertaking that is going to be heavily scrutinized by the public. So I want to assure everyone that we're taking this very seriously. I also want to emphasize that Andrew Loco was a member of the Black community who tragically lost his life. So our goal is to ensure that his life has some meaning through this process, and that it's going to guide us to do better. And I believe that the inquest recommendations are a step in helping us to achieve this outcome. So in terms of an update, the steering committee really did more of a fact-finding exercise over the last month. We met with senior city staff to really ensure that we understood the process that they undertook to engage the Black community in particular in the development of what I think was a very excellent anti-Black racism strategy. So we want to ensure that we're in line with that strategy, that any points of intersection would be addressed by our committee as well as we move forward in our work. And we also got some sound advice in terms of developing terms of reference and the makeup of the committee. We also met with the Assistant Deputy Minister, Kwatu Kenti, and his staff at the Anti-Racism Directorate for the province to also look at their strategy, their plan, and their anti-Black racism plan to ensure, again, that we're in line, we're in sync, and that at each level of the city and the province's work, that we would also be in line with that as well as a committee. I do want to update us that as of yesterday, Asifa Sarang has agreed to join the committee. She is the executive director of Across Boundaries and also a spokesperson for the Andrew Loku Coalition. So she'll be joining myself and Upala Chandrasekera, who is a member of the board, and we will begin our work immediately after this meeting, I assume. So thank you.
Thank you, Natasha, very much. Colleagues, questions? Again, thank you for, Ken.
What do you see, how do you see the, at this point, I know it's still in the initial stages, but maybe you can help us understand what you see as the primary responsibility of such a committee and the role it will play in the service?
Well, as it stands, we're an interim committee. We have not met as yet as an interim committee, but our primary goal at this point in time is to develop some effective terms of reference that will guide the development of the larger committee. That's where we are at this point. We also heard from the board in terms of the parameters that we've been given and the scope of the committee, but I think at this point in time it's really just safe to say that it's truly an interim committee that will help develop terms of reference.
Thank you. Natasha, thank you so very much, and thank you for taking the time to come here today and report to us.
Thank you.
Appreciate it. Colleagues, motion to receive Ms. Massaquo's report, Shelley and Ms. Chandrasekera. All in favor? Any contrary? Thank you so much. Next, item number 6 is presentation on the issuance of naloxone kits to specified uniform members. And Deputy Chief Ewan, are you leading this, and Superintendent Baptist? Great.
Good afternoon, members of the board. In November of 2017, the board asked the chief to provide the board with some information on the issuance of naloxones and some of the comparable services provided by other services in Canada. So as a result of that, Superintendent Baptist was tasked to look into the issues, and he has a brief presentation for the board. And any questions after?
Thank you. Thank you, Scott. Yep.
Good afternoon. Just a couple of things I brought along so people can see that, and you might be able to understand this better. This is an actual naloxone kit with two of these foil packed doses. This was what one member would receive. Pass it around. These are practice testers, and I can show you how it works. It's simply a little plastic thing in a nostril, like that. So you can pass those around, and feel free to see them. This is what a naloxone kit looks like that is given out to the public. It's an injectable format. It has glass vials, just like this. Not suitable for police use. That was the presentation if anyone's interested. Okay. everyone fully understands the fact that naloxone is a drug that can stop an overdose from opiates, synthetic opiate or any other opioid. So far this year, we have an average of, since August of 2017, the Department of Ambulance Services, Toronto paramedics, are attending 57 non-fatal and 4 fatal opioid overdoses a week in the city of Toronto. Of these cases, they administer naloxone in 9 non-fatal cases a week on average. We have a number of issues that we've considered in this. The SIU's position has been very clear, particularly of late. The SIU will invoke when their threshold is met. The admission to hospital meets that threshold for mandatory notification and or death. The law is very, very clear. Chief of Police shall notify the SIU immediately of an incident involving one or more of his or her police officers that may reasonably be considered to fall within the investigative mandate of the SIU. In terms of investigations, the director may, on his or her own initiative, and shall, at the request of the Solicitor General or Attorney General, cause investigations to be conducted into the circumstances of serious injuries and deaths that may have resulted from criminal offenses committed by police officers. That is the mandate of the SIU. The SIU potential for naloxone and the impact on the Toronto Police Service as an organization and on our members is significant, or could be significant. In 2017, we're currently averaging, over the last year, 143 days from an SIU incident to the chief being served notice that the matter has been concluded and the file closed, either by charge, the member being exonerated, or the SIU withdrawing from an investigation. So that investigation takes that long. It hangs over the top of the head of a police officer. It's an additional stressor. It causes us to report to the board in terms of movement of that police officer, if they're going to be considered for promotion, movement within the police service, etc. There is also the impact, if you consider frontline resources right now, immediately upon an SIU, potential SIU incident occurring on a street in Toronto, a supervisor is called to the scene. All police officers involved are immediately sequestered. They're directed not to discuss the incident. The police officers are taken off of the deployment. They are taken off the street. They're transported to a police station where they're held in a room. They're asked to just stay by themselves. Legal counsel has to be notified, etc. There is a significant impact. It takes the police officers off the street. It also potentially causes an additional premium pay concern in that some of the times as we wait for the threshold or notification to come back saying that the SIU intends to look at it, officers could be held for many, many hours while they wait and sit for that decision to be made. So there's a significant organizational impact. Also, civil risk. If you consider civil risk with respect to naloxone, the Good Samaritan Act allows that if, emergency first aid given by someone who would just do something to try to save someone's life, that they're covered under Good Samaritan legislation. However, police officers in this case would not be covered by that. The Toronto Police Service would not be covered by that, because of the fact that it would form a part of their duties. If they're carrying naloxone, it forms a part of their duties for which they're paid. Once they're paid for that, it is now something that they cannot seek protection under the Good Samaritan Act. The Regulated Health Professionals Act says that administering a drug nasally is a controlled act. Because it's a controlled act, it is something that has to be overseen by a doctor, and a doctor has to take care of the program for the organization. If we're going to do that, to comply with the Regulated Health Professionals Act, we would need a doctor for the Toronto Police Service to take care of this. The doctors have told us that they would have to have, the member would have to be current in their first aid training, and then take prescribed training that the doctor oversees. And the doctor would have to oversee the program. We'd have to report to them regularly, and there would be a $3,000 annual expense to that. Basic first aid, as I said, would be required for every member. We're currently 1,200 TPS members who are expired. 1,000 more are going to expire in 2018. It's a 2-day basic first aid training that would take those members off the street, again, to get that first aid training, and then they would have to do a 1-hour course online about the administering of naloxone and the properties of naloxone and that sort of thing. The drug is currently being provided free of charge through the Ministry of Community Safety and Correctional Services. That is true right now that it is free, and it's expected to be ongoing, that program, as long as the need exists. This idea of logistics, personal issuance, this is really critical, I think, for everyone to understand. We would issue a kit personally to an officer versus the officer every day signing out a naloxone kit and taking it with them and then bringing it back at the end of the day. The reason for that personal issuance is the temperature extremes at which this drug can deteriorate. So the only way to really control that is to have the officers carry the drug, be personally responsible for it, be trained about the temperature extremes, and then in the event that they know it's been exposed to these temperature extremes for an extended period of time, that there would be an onus on them to have the drug replaced. If we're going to do this, we recommend a strategic issuance. Essentially, there's 3 options. No change in our position from what we have currently, a full issuance to all police officers in the City of Toronto, or somewhere in the middle. We think somewhere in the middle would make sense if we were going to do this. Strategic issuance to all police officers working in the downtown core, divisions 14, 51, 52, and 55, which would represent all frontline officers in those divisions, 649 police officers. The reason we recommend that is when we look at calls for service for opioid crises and overdose, it's definitely it's significantly higher in the downtown core. And it's also in line with the divisions that are going to be hosting supervised injection sites. We would also recommend that supervisors in all other divisions across the city would carry it. If you consider, not unlike our TASER program, where supervisors carry it and it can be called to a scene by police officers accessing it through their supervisors. Toronto Drug Squad, we'd recommend all members because of the number of times they come into contact with synthetic opioids, and also supervisors in the Emergency Task Force, Police Dog Services, and Guns and Gangs Task Force. Again, the potential for them to come into contact with this or come across people who might require this life-saving first aid measure. At your meeting in November, you requested a review of other police services, and this is in nuts and bolts, looking at what other major services are doing with this. I think it's particularly interesting to note in this Vancouver, British Columbia, and Surrey, British Columbia, which sort of tells a lot. Vancouver has a significant issue with synthetic opioids. All of their police officers are carrying this. They also have very quick response times from their paramedics and from their fire services. So they have administered the drug 9 times total. Surrey, BC has issued it to all police officers, but the response times for paramedics and fire services are much more delayed. Police officers have a greater potential to be on scene first, and because of that, they have administered the drug, I believe the number is 139 times in the last year and a half. But if you consider it, this kind of tells the tale as you've requested. It is also particularly interesting to note Edmonton, Alberta. One of the key things in an opioid overdose, as we talked last time, is opioid overdose leads to a deep high, resulting in almost a coma-like response. The biggest issue is the fact that breathing is inhibited, and the message that can come to the heart and the lungs to stop pumping and working. In Edmonton, they are managing this problem with their protocol is to administer it, or pardon me, to issue valve bags, bag valve masks, to ensure that airways are open, that breathing continues while we can get the person, or they can get the person into the hands of a medical professional and into a hospital. I am sure you may have questions, but please.
Shelley, you had your hand up first.
Yeah, so with respect to the issues of what happens if an officer arrives on the scene of a suspected overdose or full-on overdose and treats naloxone, I think it's important for us to measure it against what happens if he arrives on the scene of an overdose just without naloxone. What's happening now when the first person to the scene is a police officer and he finds himself with a subject who's overdosing?
What would happen right now is Thanks. What would happen right now, they would immediately put in a call to the dispatcher saying that they need an ambulance to attend the scene. Ambulance and fire services would be dispatched. The first unit that would arrive would do that. The police officer, while they're waiting, would be ensuring that the person continues to breathe. They try to make sure that all the standard first aid protocols to ensure that they are continuing to breathe and monitor them.
And if he was the first to arrive on the scene, does he then have to go to the hospital with that person?
It would depend on the situation and depend if it was simply they came on to the scene of this, not necessarily. If it was someone that was...
Officers often accompany people to the hospital, so I'm just asking, is this one of those times?
Not necessarily. It depends. It would depend on a lot of different factors. Depends how busy are things on the road? Is there an ongoing investigative need? All of those things.
Okay,
Yes.
everybody wants to answer.
know if I could just respond to that in a couple of things, because it might answer some questions in advance. First off, our primary function when it comes to the overdose, it's harm reduction, first and foremost. If there is an added element, if an officer arrives on scene and there's more to it, so it's hypothetically a drug dealer versus just a person that consumes, and there's paraphernalia, then there would be a criminal investigation. In that particular case, the onward process of investigation would take place, and there would be a continuity piece where an officer would accompany. But by and large, most of the overdose situations that we come across are not criminally related. They are harm reduction pieces. We have a very robust first responder, as the superintendent said, where realistically, when those calls come in, we are only there first 2.7% of the time.
Right.
The odds of us happening to come across a situation are still the same. It's going to be 2.7. On the go forward, our decision that we've made is not the end of the day decision. We are looking at the expansion piece and ensuring that the possibility of all officers getting naloxone, but there are a couple of things that we need to further investigate. And with respect to the SIU are bound by law at this time. So I'm not pointing fingers at our oversight and saying we're stopping because of that, but they're bound by law. And so there needs to be that recognition that we need to take a harder look at that law. Our officers are not protected. I've got an obligation to ensure that I protect them as best as possible when it comes to liability issues. And so if we can further have that discussion on that particular piece, I think it's something that's important and people need to be aware of. And on the go forward, that expansion piece is alive and well, because harm reduction is important. Loss of any life is something that we do take seriously.
Right. Okay, I got that. I'm just trying to understand, because we read so many police reports. If a police officer arrives on the scene and someone is harmed in some way, we've often seen reports where the officer is now tied to that person, more or less, and does accompany them to a hospital. So why, in the case of an overdose, does the police officer, if the police officer was first on the scene, that's basically their charge lying there, why do they not accompany that person to the hospital?
It would entirely depend on the circumstance and whether there is an ongoing investigation or not. Because
So
the
what if
potential...
there isn't an ongoing investigation? Do you just say, you look okay to me and leave?
It also depends
why
on
is
the
this
medical...
different?
It would also depend on the state of the medical situation. Is there a potential that there could be, that this person could die? If there's
Right.
potential that they could die, the police officer would be maintaining involvement. There's more to it. If it appears that it's something where the paramedics might look at the police officer and say, he's coming out of it, he's okay, we're gonna take him to the hospital and get him looked at.
They're
And the-
allowed to do that.
Yes.
That's what I'm asking.
Yeah.
There's my answer. I'm sorry it took me so long to get it, but I now have my answer. So they are allowed to hand that charge over to another first responder service. Okay. Yeah.
Generally, we just don't leave a person overdose on his or her own to go to hospital. And a lot of times when we make all the inquiries, next of kin notified with a friends, responsible adults. So we just don't drop someone and says, you're going to hospital, look, everything's fine. And I would say generally, a lot of times we do put a report in as detailing circumstances, and like the superintendent and the chief said, if it warrants a criminal investigation or any further investigations that we need to do, we'll generally accompany the victim, the overdose person, to the hospital. So there are a number of variables in play, but we would never just leave the person, just go to hospital without notifying next of kin or anyone. That's, you're not going to come home and find your relative missing, and we're not doing anything about that.
And the issue here, I'm sorry, I'm really, in my mind, I'm really just on question number 2. So the issue here, as near as I can understand it, is sometimes you can hand them off to a paramedic, but if you as an officer issue the naloxone, does that then trigger something that you then have to stay with that person while they're admitted to the hospital? Is that why this is so different in the eyes of the SIU?
Yes. If an officer was to administer naloxone, now we've changed the situation, because the officer has now directly administered a drug to this person.
Right. So now he has to go with them to the hospital? Is that the issue
Yes.
here?
If that person, if all of a sudden we find out that person, the overdosed person, is going to be admitted to hospital, which is true in many, many overdose cases,
Right.
great proportion of the SIU would invoke their mandate. So now, all of a sudden, we have an entirely different investigation, which triggers lawyers, notifications, command notifications, police officers being sequestered, all of these other things that are triggered immediately upon SIU involvement.
So I guess my last question is this, and I'm struggling to get at this. It seems to me that if you're first on the scene and you find a person near death from an overdose, you have many of those things to do anyway. And I ask this question, I'm fully aware that becoming the subject officer in any SIU inquiry is the most stressful thing that happens in your life. And for officers, just because they answered a call, they can find themselves in that situation. So I'm appreciative of that. But I'm struggling with, there are a great many time-consuming things you have to do if you don't have naloxone and you are the first to arrive at an overdose scene. And there are a certain number of them. Hopefully we don't keep seeing more growth, but even if we did, we're still looking at, we've got 320 here in 2017. We already know we have more. You've named a statistic so far this year, 54, I think.
Sorry, 54 what?
That's what I'm asking you. You
Per
named a
week,
statistic
per-
that was
okay, per
2018
week.
related?
In 2018, in fact, going back to August of last year, Toronto paramedics attend, on average, 57 non-fatal opioid overdoses and 4 fatal opioid overdoses per week, on average.
Dating back to August?
Yes.
So is I thought this meant all overdoses. This count of incidents, is this deaths or is this all?
There have been-
One in
yep.
the report, it's a total of 319 in 2017. That number would be significantly higher, would it not, if it was 50 a week?
I can give you that number, just one moment.
Sure. I'm not trying to be difficult, I'm trying to understand, yeah.
Okay. The number of opioid deaths that have, this is suspected opioid deaths. This is data from Toronto Paramedic Services, not the Office of the Chief Coroner.
And this is
which are
deaths.
different
Yeah,
because
okay.
they do the most current data from the coroner's office goes into July of last year, and that is because of the length of time it takes to do full toxicology and to have a firm result with regards to alcohol, drug combinations, and that sort of thing. But paramedic data that we have shows the number of times they go to an opioid overdose that results in either their attendance or a death. And the average in that is 57 times per week to attend non-fatal. And did you take my document? No, here it is, sorry. And 4 fatal.
I'm really struggling then because I don't know what this table is in your report.
The report says 319. That's
That's
a
the total for the year.
total for the
And
year
that's
for
all-
overdose and poisoning calls from all different services in the city of Toronto, including fire, police, and E EMS.
Right, and so that's overdose poisoning, not limited to deaths. So this number should be much, much higher. If those
Which-
statistics,
This table right
if it's 57 a week, starting in July, 57 times 26, I'm
table right here is
26.
struggling.
Perhaps I could be helpful. I appreciate that when you did your report, you didn't have 2017 stats. I'm
Yes.
just looking at something from Toronto Public Health right now, which it was updated February 14th. It lists from August to February, and it says non-fatal was 1,542, and fatal was 111. I can see
That's
doing
correct.
this.
That's the data I was just citing.
Oh, okay,
Yes.
yeah.
So I should just forget looking at this table on page 16 altogether. I should just stop looking at it.
This table is looking at the number of radio calls that police, that we have in our police data set. And we were looking at a period, we were looking at this with the intent of trying to determine who arrived on scene first. So the data
Right.
is not the full, it's not strictly paramedic services data.
Right.
And paramedic services data is also, this is also by radio call, which is what is determined initially. The paramedic data is suspected incidents where they are on scene. So it could potentially be quite a bit more fulsome than what is a radio call and how it is categorized initially when the caller phones in.
Okay, so I've got, that's interesting data. I want to see that data. Maybe we could get that in a future report. In the meantime, my overall question was this, and maybe you could just speak to this in general terms, and maybe the deputy chief and the chief want to as well. It seems to me that in responding to these cases, sometimes they are near death, sometimes you have to take them to the hospital, and sometimes just your attendance on the scene and when the overdose occurs and et cetera, some of them may result in SIU claims. To be administering the drug to save lives versus the already huge amount of time going into responding to overdose crises, seems to me that all we're adding here, as in some of them, now in some of them there will be an SIU report. And that's a whole different set of circumstances. I appreciate that. But you're already spending a massive amount of time based on your stats and these helpful stats. You're already spending an enormous amount of time. Reducing death seems to me, if you don't have to report on a death, does that not save you some time? You may have to fill out an SIU report, but I'm sure there's a certain amount of paperwork involved in being on the scene when someone dies of an overdose also.
Oh, yes.
So-
Well, but it's a
So are we
sudden
really
death
talking about
report.
going from 0 to SIU report or a chunk of time to an extra chunk of time? Do you see what I mean?
I do. I think if you're speaking to the issue of the organizational impact of the SIU, potential SIU involvement, if that is what you're speaking to, I think it's really important to understand from an operational perspective how this works. Police officer comes upon a person. They're walking a foot patrol. They come across a person who is apparently overdosing in an alleyway. that police officer, if armed with naloxone and administers that naloxone, the SIU has been very clear in their position. We shall notify, and they will come and review. So as soon as that notification occurs, it triggers a police supervisor mandatory attendance at the scene to take control of it. It triggers the fact that that police officer and probably that police officer's partner are both now going to be no longer available to be deployed to radio calls for most likely the remainder of their shift, and potentially much longer than that, which incurs also an additional premium pay expense over and above. It makes the personal stressor that you commented on, that exists, but it goes beyond the personal stressor for the officer. It's also the fact that every time that person might be up for a promotion, or they might be transferring from one unit to another, they have an outstanding SIU investigation over their head, which is one more thing that has to be reviewed. We have to look at to determine the impact of it. Where is the SIU going with it? I'm not saying that we shouldn't do this. I'm saying that impact on the organization and on our members would be significant or potentially significant.
Thank you, Councillor Carroll. Ms. Chandra-Casera?
Thank you. Thank you so much for this report. I actually found it very comprehensive, and it was exactly what we had asked for in November. So I really appreciate the jurisdictional scan. That was really great, and that you found the arrival times. I found that very helpful to see that, yeah, you really are arriving at 2.7% of the time ahead of anybody else. So to ask Councillor Carroll's question in a different way is that if you arrive on the scene, so administering naloxone, I fully appreciate, sends the officer down the path of an SIU investigation. But there's also if the officer doesn't administer the naloxone and if the person dies, then it also sends them down the path of an SIU investigation, correct?
Correct.
Yeah. So considering that it's 2.7% of the time is the only time you're arriving earlier than everyone else, I think it's the issue around SIU, I think, is not as urgent, right? Because you are arriving earlier, right? So one of the things, I totally appreciate your suggestion around starting smaller, right? And with a smaller group of people, because this is something very new, and it makes sense to be cautious when starting a new process. And one of the things that struck me is the idea of having it in a certain catchment. So you propose Bathurst to DVP, Bloor to the lake, right? And I get the rationale behind that, but overdoses are happening, north of Bloor and in Scarborough and Etobicoke. So to me, it makes sense to start small, but I would really like to see this expanded to all frontline officers across the board, because even in that 2.7% of the time, even given that SIU may investigate, it's still, like Councillor Carroll said, an issue of life and death in this situation. And again, not having access to the 27 data, I've seen preliminary stats for the year, and it's much higher. We know that this is an ongoing crisis, it's unfolding. So I, at the very least, would really like to see a report back in about 6 months to see what's the status, how is it going, especially the officers that are issuing it.
Okay, thank you, Mayor Tory. And then you, and or actually then the chief, and then you, Ken.
Thank you, Mr. Chair. I just had a couple of questions, and I think the answers have sort of come out in the course of the discussion, but I wanted to clarify. I've not forgotten where I wrote them down, but having said that, I remember. First, to the chief, did I hear you correctly in an answer, I think, to a prior question that you said you'd be open to the concept of a service-wide deployment, open to it, but I think I heard you saying that was a subject in part to the resolution of some of these issues, whether it be the SIU issue or even practicalities such as how you carry, how the drug is carried and so forth and so on.
Thank you, Mr. Mayor. I think we're spending a lot of time agreeing to agree on the exact same thing, and I may have not worded it properly, so my apologies in that. I don't want people being misled and thinking that I'm stepping back because there are administrative processes. This is about life or death, and that's what we've signed up to do, and the loss of life is something that is at the forefront of everything that we do. But I also want us to be effective. In the report, we clearly state that we are in an environment where this naloxone, part of the process is the temperature issue. So being there with something that doesn't work, that's defective, is useless, and we're not satisfying our goals. That's number one. And number two, when we talk to our medical experts, they say that it is the last line of medication. That's the last thing that you should be doing. And so I don't want the misnomer that we're going to administer naloxone right away, especially when our experts are saying that's not what you're supposed to do. The training piece plays a very important role. And one of the things in certain states that do use the naloxone and does revive people, they still have carfentanil in their system. And so they're conscious, but if they don't get that medical treatment, they will die. And that has happened over and over again. And a conscious person has the right to refuse medical treatment. And so we've got an issue with that factor as well, too, because when we administer and then that person is upright and walking and fine and coherent, and then the next night they've expired, that's something that I think the public needs to understand. It's not this is administered and then all is well. So there are a lot of moving parts, and we are going about it cautious and putting it where it is needed the most with the mindset of expanding it totally. Like that needs to be explained properly.
So I was a bit unclear, and it's interesting because I did an interview with a member of the media yesterday, and they were as well. The way this is put together, and it may be just because it's you consider it to be an operational matter, and therefore it's not coming to the board for other than receipt. And I, by the way, want to back up the comments made earlier about the quality of the report. It was excellent for us in terms of people who, wanted to know the basis upon which you were reaching the different conclusions you did. But it was unclear to me as to whether you were saying you were going to do in the short term this structured deployment, and then continue to examine the issues we've just been discussing and see whether a full deployment was something that was ultimately the goal, or whether it was just saying, well, this is what we're thinking of doing, and I just wasn't clear on what it was saying. It seemed to imply you were going to do the structured deployment because it was very specific on the divisions and who would get it first, as it were.
Correct. It starts out with the structured, with the potential of expanding, and I think that is a strong direction that we're looking at moving this process.
Okay, and so the reason it's here for receipt only is because it's an operational matter in your view, and therefore it doesn't require our approval here. It just is, you're telling us this is your current intention. Okay.
Correct.
And just one more question, final, and that is, are you underway in discussions with, because I think notwithstanding the comments again that I concur with, which is that if you're 2.7% the first responder that arrives, that doesn't constitute that many SIU reports, but nonetheless, I understand all the organizational disruption that causes. But are you engaged in discussions, or would you like us to be, or who should be, with the provincial government to say, look, this law, as was the case in BC, was either reinterpreted or changed such that it could mean that life-saving, which is what you're doing here, is not considered something that is going to be an SIU reportable event?
Yeah, this is geared towards starting the process for those conversations so that we can all be on the same song sheet and to make sure that the right decisions are being made. So yes, the part of this is to now start that narrative so that there's more education and understanding of what roles and responsibilities we can all acquire to reach the most successful outcomes.
Thank you.
Chief Saunders, did you make your points? Okay. Mr. Jeffers, then it's your turn.
Yes, my question is based on the current procedures right now in looking at overdoses of crack cocaine. Because I'll give you the reason for my question is that, some years ago, three former mayors had established a task force on drugs, Mayor's Task Force on Drugs, which involved police services, board members, public health, etc. And it was at that time extremely helpful when there was an epidemic of crack cocaine. So my question is, how does this procedure compare to other forms of overdoses? Like with, for example, crack cocaine, do you do the same kind? Is it like what happens now when there's an overdose? Like, what's the procedure?
I think the difference between the opioid issue versus the cocaine issue is that we have a medication that can reverse the clock a little bit. With cocaine, you don't have that. And so the standard harm reduction piece comes into play where you call in the medical experts to come in and to render whatever first aid is necessary or possible for that moment. But naloxone is unique in the sense that it does push back the clock a little bit. It's not a guarantee, but it's something that is in play that is new when it comes to harm reduction processes.
So that the comparison that I'm asking about, you're saying that I'm just trying to fully get that.
The big difference is there is nothing with cocaine that could be administered to police officers' kits that could help with reversing time and helping a person that has overdosed on cocaine in any form. But there is with opioids.
Okay.
Okay, Councillor Lee?
Thank you, Chair. So, reading this report, saying that 1,200 officers, the certification expires, how often is this certification good for? 3 years, 2 years?
I believe it's 2 years.
2 years?
Yes.
So every 2 years they have recertified.
Yes.
Okay, so how many officers in total are you providing this to? In total? Because I can see that
Under this plan, yeah, approximately 1,000.
about 1,000? Okay. And when I read the report about the reporting to the SIU, so an officer was to arrive after the other first responders, and something does happen and the patient goes to hospital. There's no need to report to SIU.
That's correct. That's correct, because we have no direct linkage to the person being admitted to the hospital. If we arrive after the fact, then we have no obligation to notify the SIU because the police has no connection to the individual.
What happens if the police arrives and then soon after that, 15 seconds later, the paramedic arrives, but the paramedic is the one that administers it, although the police arrive first? What happens then in that case?
These are very fluid situation, Councillor Lee, and you know what? We like to take the direction that we notify the SIU and seek further guidance from them.
decide.
Yes, yeah, because these are very fluid and no two situations are the same. So we will notify the SIU and they will decide whether they will invoke the mandate or not.
And thank you for clarifying the table, because I thought there was a very high percentage of deaths from the calls, because based on 2016, 189 deaths out of 239 calls. But it would be higher than 239 because this was only for first responders, right? Yeah.
Yes, in short, that, as I said, it's the manner in which we pulled the data,
Put
and it's
enough data.
specific to radio
Okay.
calls of a certain nature.
Okay, thank you.
Any other questions, colleagues? If not, any discussion?
I'm sorry, I'm going to need a second round because during my coughing fit, it would appear the most important information of all came to light. So does it emerge that you are proceeding with implementation? Did that happen while I was out of the room? I'm sorry to ask you to repeat yourself. I had a coughing fit that was unscheduled and unavoidable.
Yeah, the answer is yes. We are going to be deploying naloxone to frontline officers, and it's in a strategic manner.
Pretty much that strategic outline that was in the presentation.
Yes,
Okay.
with a furtherance of expanding. That is very cognizant that we are looking at the expansion piece.
Okay, you're right. As hopefully the need is reduced instead of increased, but I'm not optimistic. So, did I miss? Did we get an idea of timelines? When would that be?
We can probably have our hands on a sufficient quantity of naloxone to begin equipping police officers in a matter of a few weeks. I've had initial discussions with Toronto Public Health, who we would be going through to obtain it. So there is, but unfortunately, before that happens, we require governance to be created. We need a form to be created. There are things that have to happen so that it will guide and direct. Like we need a protocol. So that is something that will have to be done. I would imagine we are probably at least a matter of a few months.
But that can be done in parallel to trying to address the SIU issues with whomever. You're rolling on your implementation, and over here the activism to resolve the SIU issues.
I believe that's correct, yes.
Okay, thank you. That changes my motion. I did write the right motion then. Okay.
You have a motion?
I do have a motion. Are we going to speakers?
Yes, we are.
I understand that it's an operational issue, but I'm moving this motion because the crisis is real, and I think we have to stay on top of it on a meeting-by-meeting basis, so that if there are snags that do require board activism, they should happen. So what I'm moving is that the chief report to the next meeting of the board on the ongoing implementation of officers being equipped with naloxone, including the model to be used to reduce overdose harm through naloxone response, and any ongoing discussions regarding the SIU impacts that the chief can share at the time of the report. Because he may make great progress with the province, and then again, he may make none, and we would want to know that a month from now. 54 deaths
Did you
later.
get that?
Yeah.
Could we pass it down, please?
There you go.
Can I just, as much as I want to help and be a willing participant, the expiry date for next month's board meeting is right around the corner. And so I want to provide tangible and meaningful content to what the request is. And so if we have to do it in this format, I'm going to have problems with that.
Councillor Carroll?
If you want to make it the April meeting, it needs to be as soon as possible. I don't want my grandson to tell me that a little girl in his class lost their mummy last night because she took a bad medicine, and that happened this month. I don't want it to happen next month.
And I understand the spirit of the request. So if there's something informal, formally April, informally, so that there is a sense that this is a priority and it's not collecting dust, we can create a mechanism for that if that would help satisfy the situation.
I think in effect, an update at the next meeting, followed by the full report, Shelley, at the April meeting. Just as Notisha gave an update today. Mayor Tory?
Mr. Chair, I would just like to support the chief's intended direction on this. I think, there's always a lot of questions that arise about who should be doing what and about some of the complications that are involved with SIU reporting and whatnot. But I think if the overriding objective, which I think it has been since this became an issue in the city, is to save lives, then this, if it saves one life, this is going to be a step forward just to have the officers with naloxone. And I also support Councillor Carroll's motion with the change, because I think in view of what was said by our officers here with respect to some of the things that inevitably, and again, I do not find fault with the fact, nor does Councillor Carroll, I'm sure, the fact that when it involves things like the SIU and its sworn officers and so on, there have to be forms. We've been told there has to be training. And so, these things take time, hopefully as little as possible, but it does take time. And so I think it's reasonable to get that report in a couple of months, but nonetheless to get it, so that we'll know the training's going along. If we can help with the SIU advocacy, we can do that. If we're told it's a problem, and so on. But I just want to say I support the chief's decision, and I commend him for it. I think it's the right thing to do, and I support Councillor Carroll's motion.
Any further comments or discussion, colleagues? If not, Arlene, have we? Yep. Scott, Peter, thank you very much. A great fulsome presentation. I appreciate it. capture everything you wish there? Capture everything you wish there? So you're proposing the motion, Mayor Tory, you're seconding it. All in favor? Any contrary? Carried unanimously. Thank you very much, everybody. That takes us, oh yes, we also need a motion, Councillor Carroll, to receive the report. Yeah, so Councillor Carroll, seconded Mayor Tory, all in favor? Any contrary? Carried, thank you. Okay, that takes us on to item number 7, which is a presentation on zero deaths, the expanded deployment of conductor damage weapons. This is something that originally we had a public consultation hearing on in October. It had come briefly, I think, in November, and so it's been reworked and coming back. And Deputy Chief McLean, you're going to do a presentation, and then there are a number of deputations.
Presentation is about how service can strive to achieve zero deaths and its interactions with members of the public. I'll be addressing the following objectives within my presentation. I will affirm the service's commitment to the aspirational goal of zero deaths when interacting with members of the public. I'll highlight that there's a gap in the ability of officers to effectively achieve the goal of zero deaths within their current response capabilities. I'll seek approval to deploy the CEW to our priority response unit constables and constables in specialized units that I will, just for the sake of ease, refer to as frontline constables. And I'll recognize that this is an issue that must balance the well-being of the public and the health and safety of officers, and then I'll outline an implementation plan for expanded deployment if approved. I'm going to be talking about frontline constables because they are the constables who are typically the first responders to 911, or what we call emergency calls for service. They often involve higher risk, and they are calls where officers need to seek a balance between using the minimal force required in the circumstances and then using sufficient force to prevent unjustified harm by subjects. And this balance often requires the exercise of judgment and often under great stress. So how am I going to get you there? I'm going to talk about the current suite of responses that offer both opportunities and limitations. I'm going to talk about our service experience over the past 15 plus years with the CEW. I'm going to talk about the accountability measures that we've put in place based on our experience. I'm going to talk about de-escalation training because it is a community concern. It's the preferred method by which officers resolve situations when it is safe and practical to do so. And you're going to hear me say that throughout this presentation. And I'm going to show that we are continually looking to improve how we train our officers. And I'm going to speak about the fact that this request cannot be taken in isolation, but rather it is occurring within a larger context of our modernization efforts. So the service is continually live to the issue of assessing other response options and best practices. On the left-hand side of this slide, it highlights the current response resources, skills, and tools that our frontline officers have available to them when called upon to resolve a situation safely. So actually, let's take a closer look at these options. The top two options, the sock gun and the shields, are relatively new. And the sock gun was introduced in 2016 as another option, a less lethal option. And the shield is something that the service is currently exploring for use by frontline constables. I'm going to ask Sergeant Mike Forrestel of our Emergency Task Force Unit to come and help me describe these two options to you. Mike?
Good afternoon, ladies and gentlemen. As the deputy said, my name's Mike Forster. I'm a sergeant. I'm in charge of the training section of the ETF. I've been at the ETF since 2008 as a supervisor, and I was previously there as a constable. What I'm going to quickly talk about is what we're talking about, intermediate weapons, because that's what we have the most experience with over the last several years. We've changed our program in terms of what type of weapons we use, because we're constantly researching, looking for less invasive sort of means of use of force. The sock round, as the deputy talked about, I'm going to have Staff Richardson come in. This is an example of what the front line is carrying right now. This is a standard Remington 870 shotgun, but what you can see is it's orange, says less lethal. The actual standard shotguns have all been taken off the road, and they've been replaced by these with less lethal rounds. All right? The round it fires is basically, in effect, a sock round. I can hand it around if you want. It's a small projectile. It's got a Kevlar ballistic weave and some lead shot inside. It's very, very small. All right, I can hand that around. The actual effective range of this weapon is anywhere from 10 feet to 60 feet. All right, but with any kind of delivery system such as this, the farther you go out, the less kinetic energy is going to be, so it's not going to be as effective. The problem with this is in terms of 10 feet is a little bit close, and in a lot of the encounters, we try and sort of keep ourselves a little bit more of a distance. All right. At the ETF, we do not use these currently. We've been using since the early 80s. We've been using an Arwin, which is a harder sort of projectile. It's usually in riots, and we have used it. Its limitations are its distance. All right. So we've actually switched to a 40 mil, sort of what is called a blunt impact projectile. It uses gelatin. It's less invasive, reduces injuries, but it allows us to get closer to a subject if we have to. Okay. So that's what we have sort of switched to. Thank you. More importantly, I think the deputy wants me to speak about shields, because that's where we have the most experience. We've used shields since probably the early 80s. It's an effective way to basically get close to an individual, especially if they're armed with any kind of an edged weapon. All right? What Officer Hicks is showing you is this is what we call a level 3A shield. It's rated to stop handgun rounds and handgun rounds only. Although it looks a little light and a little flimsy, if you are standing with it for any length of time, it can wear on the officer, and that's why we have good fitness standards. The other thing, too, is that the size of it. It's easiest for us to transport in our trucks because that's what we have. It's easy to move around and pull out of trucks, but in a front line car, maybe not so much. You can put down for a second. So before we talk about this, and we get to this is not exactly what a subject will see right away. All right? We pride ourselves on de-escalation and crisis negotiation. All crisis negotiators for the service work out of the ETF. We currently have about 45 officers that are trained. We have a significant amount of experience in speaking to people in crisis. It doesn't always include this. In fact, many of our incidents are resolved by effective communication and having the individual come out to us. So this is not the first thing that subject will see. But not everybody can be de-escalated, not everybody can be talked out, not everybody can talk off the ledge. And so depending on the circumstances, the geography, if the person's at height, if they harm themselves, if they barricaded themselves, which is primarily most of the calls that we get, then we have to introduce this, and we will actually tell people, sir, you're going to see a gentleman that's behind a shield, because at the end of the day, if Joey was to hold this up, this is not the most inviting way to talk to an individual. I can tell you from experience, this is not the way to actually talk to an individual, because if I had to say to you, sir, I'm not here to hurt you, you're going to get the wrong impression, all right? And that's why the introduction of the shield tactics that we use are really a last resort. We try to talk and have people come out to us as much as we can. When we have to enter a premise or we have to engage a subject, this shield is a very, very good deployment impact weapon, but we try and deploy another use of force option prior to doing that. Since the inception of the tasers, and for us back in '92 is when we first started using tasers, we saw a dramatic decrease in the number of injuries on subjects and also on officers. In this shield, I've been on the blunt end of a heavy cast iron poker in the helmet. That's why we wear helmets. I've been on a team where the officer went in and he was stabbed in the shoulder, from around the shield. The shield is not a complete sort of something that's going to basically deter somebody. It does introduce you in close proximity to a subject. And the closer you get to a subject, especially if somebody is armed with a knife or some kind of edged weapon or a baseball bat, increases the risk to the officer, and it also increases the potential for the injury to the subject. So previously we would deploy a lot of CS gas, but then that still did not immediately incapacitate the individual. So we would still have to go in fairly close proximity. Since the inception of the taser, when we've been using it, we will assess the individual if the taser has worked. When the person sort of goes down, we use this as a protective measure to basically pin the person, and then we handcuff them. Now there are agencies around the world, I'm told Scotland uses this for their frontline officers. It doesn't look like this, it looks like plexiglass. The problem with the plexiglass is it's a defensive measure only. You do not use it for offensive means. They do not use it to take people into custody. They use their firearms officers, which are our version of our tactical. All right? They do use them basically to contain people, but that's the only thing they do. And they have since now gone to the issuance of taser. The other problem with shield takedowns is we have the luxury of knowing the situation we're going into. The number of calls we do a year, we're averaging between 500 and 600 calls. A lot of them are not people with crisis for other reasons. But Joey and his team will constantly be training. We are mandated by the province so many hours per year. Each team will constantly train. The shield takedown, the less lethal use of force, negotiations, the de-escalation tactics, it's all a choreographed team approach. We do it, we have the experience to do it, and everybody understands the rules. All right? And a shield takedown is not simply to sort of pin somebody. There is a choreography in there. In case there's weapons that are involved, who is going to handcuff, who is going to assess that individual. So it's a team approach that we use, and that's the success we've been using. All right? We do have agencies from all over North America that do come to see us. They do call us. This is tried and true. We continue to use it, but it is a team aspect to use it. Thanks. Anything else? Oh, this one weighs about 15 to 20 pounds. If anyone wants to hold it, I can show you after. You can use it with one arm. This is the lightest shield we have. We have a level 4 shield, level 3 shield, which stops rifle guns. It's about 2 inches thicker, and it's probably about 15 to 20 pounds. All right, and you can see that you can wield this. So if I'm in a situation I can't see anything go over. All right, and again, if I'm talking to you, you'll understand this. I'm not presenting a friendly face, somebody who's actually understanding who you are and why we want to help you. All right?
Any questions? As you can see, with those
Shotgun and the shields, they will be taken to a call if some information is known beforehand. Otherwise, they will remain within the police vehicle. On the bottom of the slide, you can see that there are some other resources that are available to our frontline officers. They are the supervisor, which are supervisors equipped with a CEW. And these resources are useful, again, if the officers are alerted to having the presence of a weapon or some assaultive behavior. They can ask these resources to attend. However, with the frontline supervisor, this may not always be an option because the sergeant may be tied up on another call operationally or may be too far away to attend in a timely manner. Mike and Joey did a great job talking about some of the resources and tools that the ETF has, so I'm not going to go into any detail with them. He mentioned they are trained negotiators. They also have access to an on-call forensic psychiatrist that they can consult with for medical opinions or the best course of action to resolve something. And as Mike and Joey mentioned, they are mandated hundreds of hours to train so that they can provide that team-coordinated approach. But again, like the frontline supervisor, because the ETF have to serve the entire city, they may be geographically too far away or tied up on another call to be of assistance to the frontline officer in the moment. The MCIT is an amazing program that we have that provides mostly 7-day-a-week service to the frontline officer. They attend in concert with the priority response unit officer, and they attend calls for service for people in crisis, and they can include thoughts of suicide, self-harm, distorted psychotic thinking, overwhelming depression, or a temporary breakdown in coping skills. However, there are limitations to this program as well. The teams tend to work between 1 p.m. and 11 p.m., and they must attend in concert with the frontline constable, because the frontline constable's job is to make sure the scene is safe for the MCIT nurse who is unarmed. The other challenge with this program is that the teams are staffed when the partner hospital can assign a nurse. Sometimes the teams are shared between divisions, soon to be districts. And like the supervisor and the ETF, they may be tied up on another call. They may be too far away to attend in a timely manner, or the call may fall outside their normal scheduled working hours. So when the officer does not have prior information, and when the additional resources that I just spoke about are not available, these are the options that are available to the officer in that moment. De-escalation, it's in green because it can be used at any point that it's safe and practical to do so as the incident is being resolved. It's always the preferred choice, and in case it's not readily apparent, it happens every day. Whether that's a fight on the street, whether that's a traffic stop, whether it's a person in crisis. We train our people to respond, to use words rather than weapons. That said, our medical partners have reminded us that it takes 2 willing participants to de-escalate. It doesn't matter how skilled the officer is at de-escalation. Sometimes our public interactions involve a person under a mental or self-induced drug or alcohol psychosis that actually prohibits dialogue, that actually prohibits the ability of the officer to de-escalate. And some people present an imminent threat of harm either to themselves or to other members of the public. And a small number are active attackers. And active attackers are those who are unconcerned with escape and are focused on harming or killing others until stopped. In these situations, de-escalation is both impractical and unsafe. In these situations, immediate response is both necessary and expected of the officer. So on the left, that's what the officer has in that moment, where the officer has to make a decision to use force. So going from top to bottom, the first one is open-handed techniques. So this is when de-escalation ceases to be effective and the officer has to enable control of the person and to use force. So according to the Ontario use of force model, when the subject is unarmed and actively resisting, and the officer deems it necessary to effect a safe arrest or apprehension, open-handed techniques can be used. There are intermediate weapons, OC spray and the ASP baton or the expandable baton can be used if the officer needs to defend him, her, or themselves from being overpowered or being assaulted by a weapon. And of course, the last option, which is always deemed to be our last option, is the firearm. But it is a lethal weapon. And just to be clear, with regards to the firearm, officers are trained to shoot at the center of mass of the impending threat. This is necessary for the safe and effective use of this lethal option. Therefore, any notion that the officer could be trained or expected to wound or otherwise incapacitate is not practical. However, like I said, it is our last option. So I did dug up some analytics, and I chose the years that the service has been reporting data to the board on CEW. And I wanted to make this presentation based on the Toronto context. So I've chosen SIU incidents. So these are incidents where the SIU invoked its mandate. Doesn't necessarily mean that it resulted in criminal charges, but it resulted in injuries or deaths to members of the public. So while many might think that the empty-handed techniques are in fact less injurious, our data shows that that's not the case. You can see that officers were involved in 223 incidents where a member of the public was injured in the blue graphs. In this case, 4 persons died. You can see that the use of firearms within those last 11 years, 37 persons were injured and 25 persons died as a result. You can see that there were 2 incidents of serious injury with use of the CEW and 0 deaths between those 11 years. And just for some context, I've put the total number of arrests during that time. And I've chosen arrests because arrests can be unpredictable, and they can be violent. And you can see that in those 11 years, we arrested just under 500,000 people. And during that time, we used the CEW just over 3,200 times, with half of those times being a display only, with officers reporting an over 88% effectiveness in terms of its ability to resolve the situation. And there were 31 minor injuries. And minor injuries, just to give you an idea, they could be cuts to the head that resulted from the subject falling before the officers could secure the person, and the person needed stitches. So I'm going to narrow down that data to the last 4 years. And I'm going to pick 2014 because that is the first full year after the service requested the board to expand the CEW. So you can still see from the data that empty hand techniques still create the most injuries to members of the public. You can see that in those 4 years, 10 persons were injured and 7 persons lost their lives. Again, the CEW, 2 injuries, serious injuries, and 0 deaths as a result of the use. And during that period, we arrested just over 117,000 people. The CEW was used just over 1,200, again, with 50% of it just being displayed. So as I mentioned in my opening, the health and safety and well-being of police officers is also an important consideration within this discussion. So in fact, when I made this presentation to the board's mental health subcommittee last week, a member asked me about injuries to police officers. And you can see that in addition to the welfare of the community, the health and safety of officers is top of mind for the board as the employer. And the service has been reporting occupational health and safety data since 2005, of which report is actually part of this month's board package. So I've chosen injuries, what I'll call IODs, or injured on duty reports, which resulted in a WSIB claim over the past 4 years. Again, 2014 being the year after the service first approached the board to expand. And you can see with WSIB claims, these are incidents where the member either sought health care and or lost time. So you can see that the category in blue is the number of times officers have been assaulted by either arrested parties, suspects, or members of the public. In red, I've also included the overexertion category. And it reveals a significant number of injuries resulting from suspects either resisting arrest or engaging officers in foot pursuits. And I've added these again to give you a context of what's happened in Toronto. And you can see these are contexts where the health and safety of our officers have been in some ways compromised. You can also see that last year the service experienced a spike in these occupational injuries. So you can see the 4-year average plotted with a yellow line, and you can see last year's were significantly above those 4-year averages. I've asked our OHS unit as to why, and at this time we don't have a response other than there was just a greater frequency of these occurrences happening. You can see that the costs for the 2017 IODs are currently at $1.1 million. They are expected to increase because some members are still undergoing treatment. And what's key about this graph is that police officers are considered workers under the Act, the Occupational Health and Safety Act. And that's not always taken into account with this discussion. Under this Act, the board, as the employer, and the chief, and every other supervisor in our organization have joint and related responsibilities to take every precaution reasonable in the circumstances to protect workers from both hazards in the workplace and workplace violence. So while the Act allows some workers to refuse work, it doesn't allow police officers that right. So as such, police officers are expected to place themselves in situations that could be considered violence or situations that threaten their health and safety. So given the data describing the service's experience within the last 11 years since 2007, it's reasonable to conclude that the CEW could reduce the number and seriousness of officer injuries as well as injuries to members of the public. And this was findings that is consistent with some of the reports that were quoted within the board report. So based on our experience and the outcomes revealed by our data, we believe that there's a gap between the tools that the officers have immediately on their belt and their ability to achieve zero deaths when interacting with members of the public. The service believes that the CEW is a bridge between threatening and assaultive situations and safety. We believe that it is a tool that has the potential to save lives. And we believe that this gap will narrow with the deployment of the CEW to the frontline constable. So now I want to move the discussion to accountability. So I want to talk about some of the measures that the service has developed over its experience over the past 15 plus years with the tool. As the board, you need to be satisfied that the service is thinking about oversight of its CEW program. The first piece of oversight is our procedure, which is clear that the CEW is not meant to increase the application of force by our officers. Rather, the CEW is an additional option that will reduce fatalities and serious injuries. Add to this the Ontario use of force model, which assists officers in determining the appropriate use of force and articulating their decision to use force. Add to this some of the improvements in our training that I'm going to speak about in a moment, all of which are designed to inform the officer's decision-making when presented with threatening and assaultive behaviors, or people who pose an imminent threat of serious bodily harm or death. And an imminent threat is defined as someone who has the means, the opportunity, and the motivation to carry out that threat. And that includes threats or attempts of suicide. So to ensure that the CEW is used lawfully and effectively, the service has several accountability systems in place. I've already mentioned our procedure. In addition, the weapon is tested daily before each tour of duty to ensure that it's functioning. Each CEW has an internal data system, which is audited to confirm usage and condition. The service has an early intervention system to monitor CEW uses and triggers an alert when a threshold is met in a prescribed period. And speaking of the built-in device tracking, when the CEW is used, specific paperwork must be submitted by the officer. And that's a specific CEW report, that's a service report, along with a provincial use of force form and officer's notes that describe the event and the decision-making. These documents are reviewed by the member supervisor, unit commander, and our use of force analyst with the purpose of identifying any breaches of law, policy, procedures, or training concerns. A note about our use of force analyst. So this is a sergeant who has been in this role since 2011. This isn't a position that we cycle a lot of people through, and in that time she's built up an expertise in terms of reviewing incidents and their associated response. The service also has a use of force committee. Sorry, let me just put that down. A use of force committee whose mandate it is to meet quarterly to review the application of force, to assess the effectiveness against the service's training, policies, and procedures, and then make recommendations right up through to senior management. And lastly, each year the service submits an annual report to the board talking about our CEW use, including a description of the person against whom it's used. And this report was actually an example of full public, was acknowledged as an example of full public disclosure by Commissioner Braidwood when he did his work. I'll talk about Human Resources Command at the end of this presentation. So de-escalation is a very important element within this discussion and within our service's request. I'd like to start by acknowledging our critics who have voiced concerns that officers will abandon de-escalation in favor of the CEW, and that de-escalation should be the preferred means of resolving a situation. We could not agree more when it's safe and practical to do so. It's not one or the other. The service recognizes and committed to the role that de-escalation plays in every encounter. In fact, we've increased our emphasis on de-escalation and negotiation as the primary means of resolving situations. In fact, we've added 3 weeks of judgment and decision training to our in-service training program, to our recruit training program, and a 3rd day to our in-service training program. So our in-service training program is the main way that we train our officers, all of which have been dedicated to de-escalation training. Within our defensive tactics portion of our in-service training, officers are taught to think about the reasonableness of their application of force, especially if the person is in crisis. So before I go on, I want to talk about what de-escalation is. It includes verbal and non-verbal strategies and tactics that are designed to decrease the intensity of the situation without having to use force, or if force is necessary, to actually reduce the amount of force needed. Okay, I'm going to talk about what our de-escalation training is made up of. And there's no way I can do this justice. We would be here all day. But it starts with the Policing Standards Manual, and it requires some legal requirements within the use of force, judgment training, safety, de-escalation tools and techniques, and then, of course, scenarios to reinforce and demonstrate the learning. But we don't stop there. So that's what's required. We also look at commissioned and uncommissioned reports. These commissioned reports we would consider Justice Iacobucci's report, Police Encounters with People in Crisis, our Police and Community Engagement Review report, as well as external reports that include inquest recommendations and other reports. They are in our board report, so I won't go into that too much. But I will say that we actually consult with others who have lived experiences that actually help inform our training. Service also, on that note, consults with stakeholders, and there are a number of stakeholders, particularly who are experts in mental health, curriculum design, and those who have, again, lived experiences who can inform our training to make it effective in our Toronto context. Again, they are too numerous to go into, so I will just list them here. And finally, we engage in professional partnerships. Again, those who can help us with curriculum design and evaluation, and these include a number, including our most recent announcement of our academic partnership with the Chang School at Ryerson. So I'm going to look at, bring you through some of the evolution in our in-service training program curriculum. I'm starting with the year 2013 because I had a conversation with Dr. Judith Anderson. And in that conversation, first, Judith Anderson is a researcher that's been hired by the ministry to respond to the Ombudsman's report, A Matter of Life and Death. She mentioned in that conversation that she had seen our in-service training in 2013, and she had seen it recently for this project, and that she thought our training had improved leaps and bounds since 2013 when she first saw it. So in 2013, you're starting to see a real emphasis on human rights, crisis intervention techniques, and it really incorporated the lived experiences of members of the community as they related to mental health and drug addiction. A member in this curriculum, a member of our service actually spoke about his experience with his brother's mental illness, and it's the first time that at least I can remember having a testimonial from a member dealing with his family's experience with mental illness. This course, in 2013, we also had testimonials from MCIT nurses and our MCIT officers. Again, building rapport and respect, and then designing scenarios to reinforce and demonstrate that learning by the officers. In 2014, we're starting to see more concepts of de-escalation by experts. And we also added the fair and impartial policing curriculum that year, which really underscored that even well-intentioned people have biases, and that can influence decision-making without conscious thinking or overt decisions. You can see in 2015, we added the negotiator workshop to our front line, which was hadn't occurred before. It was the first time, even within other services around Toronto. You can see that we're focusing on active listening skills and building rapport to influence the subject's behavior. We had information, also including information from several of the reports that I had previously listed, and looking again at introducing scenarios that officers can practice the skills and demonstrate that they are applying the learning of the program. In 2016, we added an emphasis on threat assessment and the role of the secondary negotiator. And this was the year that we added the third day of the in-service training program. And this day was dedicated to emotional intelligence, to elements within Recommendation 12 within our PACER report, further human rights training, articulable cause, customer service elements, to name a few. Again, and these were emphasized both within the classroom and within scenarios. Members were encouraged to take the Harvard Implicit Association test to help them promote some self-awareness of any attitudes and beliefs that they may have. Moving on to 2017, saw a further emphasis of the Think, Act, Explain model, focusing on the reasonableness of decision-making, and as well as reducing the intensity of the situation, which is the vision for incident response. Officers were also taught to manage their own jeopardy and to think about how their actions or their inactions actually can contribute to a situation. Further bias avoidance training was added. And then the 2018 program incorporates the de-escalation framework that is appended to today's board report. And it focuses on teamwork and planning, which was a recommendation from the Andrew Loku inquest. The lectures focus on tactics before weapons, and scenarios reinforce that main learning objective. So, a number of agencies have visited the Toronto Police College looking at our training, and we have received positive comments for being leaders in police mental health and de-escalation training, particularly from CAMH and the Mental Health Commission of Canada. I'm not going to read this entire quote, it's in the board report, but Dr. Terry Coleman visited the college in 2015, and he really talked about outcomes for officers and outcomes for persons in crisis. And you can see that he did that in 2015, and if you remember in 2016, that is when we implemented, based on his comments, consideration of the subject's state of mind during the defensive tactics training, the third day to ISTP as well. So, while the CEW is not without risk, I'm not going to stand here and say that it is risk-free. We're confident that based on our evidence provided by our own experience over the past 15 plus years, that it is a less injurious option for our frontline constables. And we believe on this experience that it has the potential to save lives. So if approved, we would issue the CEW to frontline constables in a controlled manner, starting with our coach officers. And we're starting with them because they are officers who are selected as leaders by their unit commanders. They have to complete some training, extra training to be in that important role. And this extra training includes not only evaluation, but additional use of force reporting. I believe that the service's new competencies, of which I was here last month introducing the board to them, play a role in not only how we select officers, but also how we deliver our training and our training curriculum. Particularly emotional intelligence, our solution-focused, accountable in delivering results, and our service and community focus. So we are looking at behaviors that identify solutions where officers make sound decisions, and they look for the best outcomes for the service and the communities that we serve. And at this time, our CEW training is being revamped to incorporate these competencies and core values. So we believe that this recommended and controlled issuance provides the service with the opportunity to monitor and to measure, and then include these results in any reports to the board. We're also revamping the actual CEW training that we deliver to our officers. So while participating officers always had to successfully complete ministry-approved training, our training is going to increase to 20 hours of both study and scenario-based exercises. This is a full 8 hours longer than the provincial standard and 4 hours longer than the previous course. De-escalation will be a cornerstone of this CEW training, and the 4 hours will actually emphasize our de-escalation framework, and more scenarios will be added involving the use and the non-use of the CEW. The goal will be resolution without force unless the threat is imminent. And always the officers will have to demonstrate proper use of the CEW. And it was always the case, officers who fail to meet those ministry standards will not be issued the CEW, and annual recertification occurs every 12 months. So we believe that officers should have more appropriate options based on comprehensive research to lead to zero deaths. We believe that the public, by way of their representatives in police governance as well as police leaders, we have a duty to provide officers with evidence-based suite of responses to safely address those situations where they have to make the decision to apply force in our communities. We believe that these responses must always be governed by the continued emphasis on governance, training, innovation, supervision, and accountability through public reporting. So based on our experience with our current suite of responses in our Toronto context, which we consider to be an evidence-based approach, we believe in good faith that the addition of the CEW provides officers with a less injurious option that will narrow the gap between their current capabilities and the goal of 0 deaths. If our request is approved, the service recognizes that an emphasis on de-escalation is a community concern. I want to reassure you that it is a service concern. To address that, a significant portion of this presentation was devoted to providing an overview of the continual improvements that our service instructors make and will continue to make. So going forward, the service will continue to study international best practices for incident response. That's not going to stop, as well as de-escalation training. We'll continue to research and implement stronger measuring tools to ensure that we have compliance with our CEW governance, and we will move quickly to address any issues that are identified. I'd like to take this opportunity to remind the board that this request should not be considered in isolation. Rather, the service is modernizing and moving toward an even more community-centric service model, and we are starting to see some of the outcomes of our efforts. One of these efforts is a new organizational chart that will be presented to the board in the coming months. This new structure includes a Human Resources Command comprised of 2 important pillars, people and culture and corporate risk management, both of which are under the oversight of an operational deputy who is responsible for the service's people management practices. This new command includes the traditional human resources functions of recruitment, promotion, wellness, and safety, to name a few. And you'll remember that we were here in October with a plan to modernize these functions to support the board's business plan. And in addition to these capabilities, the new Human Resources Command also includes units responsible for conduct oversight, the service liaison with the OIPRD, with the Special Investigations Unit, as well as professional standards, legal services, governance, and the Toronto Police College. Therefore, the centralization and the coordination of these units' mandates will actually support more effective people management in general, and specifically a coordinated oversight of the expanded CEW program if approved. So in conclusion, the board has asked the service, how can it achieve 0 deaths in its interactions with members of the public? The service believes that after examining this question and its experience within the Toronto context, we believe that limitations exist within our current suite of responses. The service believes, based on its experience, that a gap exists in the officer's ability to more fully achieve this goal, a goal that we wholeheartedly embrace. And the service believes on good faith that this gap can be narrowed by adding the CEW, which has proven over the past 15+ years to be a less injurious option to address the application of force in our communities. And as such, the service is asking the board to approve the expanded use of the CEW to frontline constables. And I'll stop there and take any questions.
Thank you, Deputy McLean. There are, I'm sure, a lot of questions, but I think we have a number of deputies first that I want to hear from, so we get it all together. So if you could just stand by, thank you. There are, as I said, a number of deputations. The first is John Sewell of the Toronto Police Accountability Coalition. And John, thank you for providing us with a written copy. And
thank you, Mr. Chairman. A number of people have mentioned the meeting that was held on October the 18th last year on this subject, and at that time we drew the meeting's attention to the recommendations of Mr. Justice Iacobucci in his report in 2014, just over 3 years ago. And if you remember, it was the police service who retained Mr. Iacobucci in order to get his advice. And of course, one of his pieces of advice was recommendation 59, that the Toronto Police Service consider conducting a pilot project to assess the potential of expanding conducted energy weapon access within the service, and he had a whole bunch of ideas about how that should happen. In fact, he made a total of 16 recommendations about CEWs. What's of course interesting is that the presentation you've just heard, all 41 minutes of it, and the 26-page report that you have before us doesn't even mention Mr. Iacobucci's recommendations. You ask for them, he comes forward, he says, here's what you should do if you want to get more CEWs. They don't even mention it. 26-page report, 41-minute presentation. It seems to me, if you're interested in getting more CEWs, listen to Mr. Iacobucci. He's the guy you've actually retained. He's the guy who gave you the advice 3 years ago. And we think that what is required is that, in fact, you actually proceed that way if you want to go that way. We don't believe that going that way is the right way to go, but if that's what you want to do, please take his advice. And all the side talk, because that's what the report is, that's what the presentation was. It failed to come to grips with what he had recommended. It doesn't really prove the case. And we think that, in fact, CEW's use should be curtailed and not expanded. We think that, in fact, at the end of the day, if you're talking about trying to transform the police force, don't give them more weapons. That ain't the way to go. That's the wrong way to go. A transformational force will have it behaving in different ways. And weaponizing it even more is not going to be something that happens. We think the $1 million you want to spend on that, of public money, is much better spent on transforming in a different way so police culture works in a fundamentally different way than it's working now. And lastly, we'd like to say that we endorse the report of Marie Moliner. We think it's a very strong report. But not only that, we endorse the report you have before us from the Canadian, the CAMH. It says don't go ahead. And with the Canadian Mental Health Association, it says don't go ahead. You got really strong advice. Iacobucci on the one hand, and then these professional organizations on the other hand saying don't do it. And our advice is don't do it. It's the wrong thing to do. Thank you very much.
Thank you, John. Are there any questions of Mr. Sewell? John, thank you. Next, Antonella Scali from the Schizophrenia Society of Ontario. Antonella, I'll give you 5 minutes, and I'll give you a 1 minute kind of warning.
Thank you, Mr. Chair.
Thank you.
So my name is Antonella Scali. I'm a policy analyst with the Schizophrenia Society of Ontario. Thank you for the opportunity to present to the Toronto Police Services Board on the proposal for achieving zero harm, zero death, an examination of less lethal force options, including possible expansion of conducted energy weapons, or CEWs. As you may know, SSO, as we're called, is Ontario's only not-for-profit charitable health organization dedicated to supporting individuals, families, caregivers, and communities impacted by schizophrenia and psychosis province-wide for the last 38 years. SSO has long supported families and families of people with schizophrenia and psychosis and other mental health issues, and individuals who have come into contact with the law. Our key considerations on this topic have been informed by our work in the area of justice and mental health, and most importantly, persons and families with lived experience. SSO commends the Toronto Police Services for its progress on responding to recent inquests and recommendations, and for its ongoing work toward improving police interactions with people with mental health issues or who are in crisis, by, for instance, increasing the emphasis on de-escalation that was discussed as a primary means of resolving potentially confrontational situations. In addition, as a member of the Mental Health Subcommittee, we are encouraged by the board's leadership in developing a comprehensive mental health strategy to better serve people in crisis. It is clear that the police and the community prefer zero harm and zero deaths in any police interactions, especially those involving already vulnerable groups, such as individuals with mental health issues. This is why we continue to have reservations about the proposal to expand the deployment of CEWs to on-duty primary response unit constables and constables from designated specialized units. SSO has long supported a zero harm approach to all interactions with police and people with mental health issues experiencing crisis. While availability of CEWs may increase officers' ability for self-defense and allow for greater options in responding to potentially dangerous situations, availability of any weapons may consequently decrease utilization of nonviolent techniques such as de-escalation. The purpose of using de-escalation techniques and all of the training that has been happening is to diffuse a situation without the use of force, and in particular lethal force. As training and protocols that continue to allow for the possibility of use of force are incongruent with this approach and may preclude effective utilization of this approach in real-life scenarios. As an alternative, we support the expansion of nonviolent tools such as continued expansion of de-escalation and training, and increasing access to mobile crisis intervention teams for responding to people in crisis. There's also a lack of robust evidence around the potential harms of CEW use, specifically a lack of real-world evidence about the potential risks of harms, in particular to vulnerable groups. So these could be people with mental health issues, people who are on certain medications, people with pre-existing medical conditions. In review of, as mentioned in Iacobucci's report, it was recommended that TPS advocate for an interprovincial study of the medical effects of CEW use on various groups of people, including those in mental health crisis. This has not happened yet. We have concerns that the use of CEWs may pose an increased risk for people with certain conditions that our client population are at higher risk for, things like cardiovascular disease, things like concurrent substance use disorder. We also have very big concerns about how the expansion can be scaled back if it does result in overuse for certain groups. It's further extremely concerning that available evidence shows that police use of force occurs predominantly in individuals who are intoxicated or who are emotionally distressed. Studies raise the concern that tasers will be used disproportionately on people with mental health and addictions issues. This is particularly concerning because, as I mentioned, the increased risks of our client population. For these reasons, we propose the following recommendations. Designate zero harm as the goal for all police interactions with TPS policies, procedures, and protocols. Do not expand CEWs to frontline officers in Toronto, considering the issues mentioned. Continue to expand and draw on de-escalation training, and expand the current system of rewards and incentives to acknowledge officers who effectively resolve crisis situations without use of force, and set this as the standard of conduct for all police practice. And of course, expand the use and availability of mobile crisis intervention teams. As mentioned, there are current gaps in the resources available currently in Toronto. We'd like to see them operate 24/7 in all TPS divisions in the city. We'd like to see the consideration of expanding their access as first responders. In closing, CEWs are not non-lethal weapons, and their use has caused significant injury and death in the past. So thank you so much.
Colleagues, any questions? Ms. Shandakasera?
Thank you so much. I'm really interested in what you said about the medical impacts of using CEWs. Can you expand a little bit on that? And because you were talking about disproportionate use on people, your client population.
Absolutely. So we know that people with schizophrenia have increased risk of cardiovascular disease. They have earlier mortality due to that illness and other medical conditions. We also know they're at increased risk for concurrent substance use disorders, so having an addiction in addition to the mental health issue. From what we understand from the research we have seen, there is concern that people with these underlying conditions could have a different response to the use of CEWs. So their risk of physical harm is different than it is, for example, for myself, who doesn't have the same level of health issues. we're worried that not only is it going to be used for people in crisis as a response option, but we're worried that those people may have even greater risks of the physical impacts that are associated with CEWs. Does that?
Mr. Jeffers?
From your experience, what options are there when or if the de-escalation techniques are not working with a person who's in a state of mental crisis and not perhaps thinking rationally or logically? What would you suggest in that situation?
I would suggest, I mean, right now we don't have full response through mobile crisis intervention. We don't have, as was discussed, there are gaps in being able to respond to those situations. So recommendations like expanding access to those options for that additional support to be able to create greater opportunities for the time and the required time and effort for de-escalation. We would like to see that happen first. And as was mentioned earlier in the Yakabuchi report, I mean, we haven't, we don't know what the full impacts of this are for our population group. And there has been no pilot that has looked at those risks at all. So we don't know the full answer of what could be available if we did have expanded MCIT response, if we did have better intervention and supports before it gets to that point of crisis for people. Does that answer your question?
Okay. Well, thank you very much. Any other questions, colleagues? If not, thank you very much. Do you have a written copy of your?
We can send that
Great.
along.
Thank
Okay,
you
thank
so
you
much.
so much.
Next is Don Wades. Okay. Jennifer Chambers, and I think Jennifer was here but had to leave, and she warned us of that in advance, so she has left us a written copy, which I would refer you to. Chris Langenfeld.
Mr. Pringle, Chris asked me to tell you he was outside and wasn't allowed to come into the building because he would be arrested.
Okay, thank you. That means he was not prepared to go through the security. Thank you. Brian DeMatis? Matos, I'm sorry, Brian.
That's all right.
I think I got it wrong last time, too.
My computer crashed, so I'm going to have to wing this, so I apologize.
You know the rules, 5 minutes. I'll give you the 1 minute warning.
Yep.
Thanks.
Obviously, when dealing with escalation tactics, we do know that there is a disproportionate use of violence when it comes to marginalized communities, including queer and trans communities. I am very offended by this report that's been stated, because if 0 deaths are the goal, yet we do nothing to tackle the toxic masculinity and homophobia, transphobia, anti-Black racism, anti-Indigenous racism that does exist in police culture daily. When we're talking about mental health, folks with mental health issues and addictions, we need to analyze concurrent disorders that do impact what it means to talk and how to talk to folks. We realize that SBC syndrome is pretty big, especially with folks with addictions and mental health, which is suicide by cop syndrome. And 0 deaths does regard on many aspects that we need to not rearm and spend resources on arming the police with a strategy that doesn't dis-escalate violence. As we know, tasers can do a lot of damage, especially if you have pre-existing conditions, especially if you're a certain age, especially if you're certain, damn it. So my biggest recommendation is you stop with the tasers and start with the training.
Thank you, Brian. Any questions of Brian, ladies and gentlemen? Okay, thank you. Next, Desmond Cole. Okay, he's not here. And finally, Dion Rene. Okay, thank you, colleagues. And I just draw your attention yet again to the fact that there are 3 written submissions in your package, and that the Canadian Mental Health Association, the CAMH, and Quan Mackenzie. And on top of that, as I mentioned earlier, you have Jennifer Chambers's. So perhaps, Deputy, you could come back up, and colleagues, we could get into questions of the Deputy and then the general discussion. Questions, colleagues? Ms. Shandor-Cusero?
Thank you. Thanks so much. I have kind of 3 buckets of questions for you. One around the training, one around the MCITs, and then one around CEWs. Firstly, thank you for inviting the board to the training day back in December. Ken and I both attended. It was great. It was actually the second time I'd seen the training. The first time I saw it was years ago with the mental health subcommittee, so it was really nice to be refreshed and observe that. I know that a lot of energy's gone into the training. I know you have a great curriculum. As you demonstrated today, a lot of people have provided their input. I was very happy to see the simulation. That is an evidence-based practice. So, I'm not going to critique the training. I think that what you're doing is great. Some of the concerns I have is, when we think about the Andrew Local inquest, testimony was shared that the responding officer could not recall some of the de-escalation, right? So for me, I think training is one component of this very complex issue. So we need to move beyond the training and look beyond the training to see what other supports are there. And especially in crisis situations. So one of the things I've been thinking about is, you get about 80 calls a day in terms of mental health crisis situations, right? So what happens before the officer arrives on the scene? How much information do they know about the situation? Do they know if a weapon's involved? Do they know it's a mental health crisis situation? Do they know if it's an overdose or opioid-related emergency? The more information the officer has before they arrive on the scene, the better prepared they are for de-escalation, right, if they know what they're going into. So to me, in terms of training, it seems that it's equally important that, just as we train the officer, that we train the person taking the calls and people working in the call center. So can you talk a little bit about what training is provided to people in the call center?
Yeah, you want to?
Yeah, certainly it's part of the training. Just to be clear, call taking alone is a 6-month training process. So persons in crisis is part of it. Every single issue you brought up today is something that somebody would be asked about on the phone, from whether or not there are weapons involved to whether or not drugs or alcohol are a factor to whether or not they are in crisis or having thoughts of self-harm, that sort of thing. And in fact, the training is very dynamic. It goes from a classroom situation to a simulation situation to actually working one-on-one with someone on the phone, to having a mentor right by your side to help manage all of that. One of the reasons that we have people not pass through that process is the inability sometimes to connect with people. That's a really big piece around how do you get the information in very dynamic situations. It's an extremely difficult job. So absolutely, all of those things are factored in. And I'm just reading the last thing that we talked about. Sorry, the last piece is it is really important sometimes to understand that with respect to the information that you receive online, that it is, of course, self-disclosure. So sometimes people are not able to articulate what is happening to them. Sometimes it's another person calling who just doesn't know. So we seek as much as possible to get that information, but it is fairly common, even with the best of efforts and all of the training that goes into the call takers, to have situations where people are just don't know what they're doing.
In terms of the call center staff, is there a role that they play in terms of prompting the officer who might be walking into this situation?
Absolutely.
Thank you, that's very helpful. So that's kind of before they arrive on the scene. So once they arrive on the scene, you talked about MCITs as part of a a resource that's available to them. But then you also raise that, you know, it's not available 24 hours a day, and not in all areas. And, you know, lots of people today in the deputants have talked about Justice Ikubuchi's recommendations. And, you know, his recommendations specifically were that MCIT should be expanded to 24 hours a day, and that we should be exploring whether MCITs can act as a primary response team as opposed to a secondary response team. And then also that whether MCITs can be enhanced to respond to drug and alcohol-related emergencies as well. Justice Ikubuchi also recommended the Crisis Intervention, or CIT program, which has been, I know, used throughout Coast Hamilton and with the OPP as well. I've seen that CIT training as well. So and that would be available for our officers to respond if an MCIT isn't available, right? So I'm wondering, what's the progress on implementing those recommendations, and where are we at? Because I also saw the report that was developed, that was shared with the Mental Health Subcommittee in November on the quality improvement evaluation of the MCITs, which said, you know, it's working well. The problem is it's not available. And has it been contemplated, the expansion of MCITs?
So I'm going to ask Chris Body to answer some of that, but I'm going to ask, respond to, can the MCIT be a primary response? I'm going to say no, because the nurse is not armed. So as I mentioned in my presentation, the MCIT is usually a secondary or a co-responder, and that is because the PRU officer's job is to make sure that the scene is safe, not only for the person in crisis or anyone else there, but understanding that our MCIT partner, the nurse, is coming and he or she or they are unarmed.
Great. Thank you. So as far as the MCIT expansion, we've always committed that if we could get more nurses, we would commit to police officers. And of course, the nurses are employees of the hospital. And of course, we employ the police officers. So that's the stumbling block as far as expanding that. We do have coverage throughout the city, 7 days a week, just not 24 hours a day.
So I fully appreciate working in healthcare. We're strapped for money too. Has there any been thought given to, you know, I know you're setting aside some money for these CEWs, perhaps using some of those to approach a healthcare organization to see if they would be willing to come to the table?
So we've had the discussion, so we're working on that.
Okay. So my next question is around the CEWs itself. So in terms of what you're proposing, how many officers are we actually talking about? So I understand it's about 1,800 PRU officers. So how many would that be that would have access to a CEW in a 24-hour period then?
So in a 24-hour period right now, it's however many supervisors are on the road. 1, 2, 3, we don't know. It would depend on if they are on annual leave, if they're on course, or if they're absent for some other reason. In terms of if this is approved, I can tell you that we can train about 100 officers per month. It's a smaller class. So not only is the training being expanded, but the class is smaller than our usual classes. So we normally train anywhere from 20 to 30. We are keeping the classes at 15 so that there can be more one-on-one work between the instructor and the officers. So by the end of the year, we could probably train in and around 800 if everyone can be scheduled. We can schedule that if the divisions can send the officers. That's roughly what we're aiming for by the end of the year.
Okay. So on page 24 of your report, you talk about that since 2007, the rates of injuries, and you showed that, right? And so you said CEWs have been used through over 3,000 times, and during that period, quote, 2 people have received an injury serious enough to invoke the SIU mandate, and 1 person has died. The cause of death, however, is yet to be reported. Do you have any projections on how this might increase with the increase in officers that you're planning to deploy this year?
I'm going to say no, because again, the use of the CEW is driven by the behaviors that the officers encounter. So if the officers encounter an immediate threat, that's when the officer has to make the decision. So it's too hypothetical a question for me to even, and I don't want to provide an answer that wouldn't be accurate. It's not known right now. It will be one of the metrics that we do look at.
Okay. My last question on this. One of Justice Ikabuchi's recommendations was that if CEWs are expanded, that every officer that's issued a CEW should also have a body-worn camera. Has that been contemplated?
Yeah, the body-worn camera program is something that is separate and distinct, and we've had some learned lessons based on a pilot that we did last year. My ambition is next year to be rolling out the body-worn camera program, and right now it is before the Fairness Commissioner, who is looking at providing the best options that are Toronto-centric.
I see. So if we're thinking about a timeline, will that be happening first before the CEW expansion?
No, I hope not. No.
Mr. Jefferson?
Yes, you know, in this whole discussion around the use of tasers, excuse me, I held some discussions with members of the anti-black racism groups, right? Who expressed, of course, and mentioned that a disproportionate number of black people have been, have been victims of lethal force. And the question was, if there was use of tasers, would many of them be alive today? And I thought that was very interesting because, and so what I'm asking, one of the questions I'm asking here now is that in your projection and your analysis of all of this, has that been any part of the discussion that victims of mental health or people who are disproportionately fell victim to lethal force, would they be alive today? And as some of them have said, and not everybody agreed, of course, but some of them have even stated that the victims of tasers would be alive to challenge legally, and so on and so forth. So I'm wondering, have you done any sort of discussion or speculation on that?
Thank you. I can only answer that hypothetically. It's possible because in that interaction, if the officer had a CEW, then that would be another decision point that the officer could make. If the person in the interaction has a firearm, the officer's not going to react with a CEW. So I can only say, based on what the officer is faced with, having a CEW is another decision point, so it actually changes the analysis of the situation. Without it, the officer now goes from an intermediate weapon of a baton to a firearm. Those are the choices that the officer has in the moment. So looking at the situations, again, it's hypothetical. You can only assume that the officer would have that other decision point, and it's quite possible that some people would be alive today.
What is the psychological aftermath of an officer who has used lethal force, for example? What can you just maybe talk a little?
I can only say in the context that I've heard Dilnaz Garda talk about the effects on her brother and their family, and that is why she was invited to speak at the public consultation in October, because again, that's, as I mentioned in my presentation, the effects on the officers to have to make that decision in that moment to shoot or be shot or to harm or be harmed is a decision that the officer has to live with after that encounter. And you will note in the Occupational Health and Safety Board report that's in your package, we are actually seeing more PTSD incidents being reported to us. So I can only go on what Dilnaz said was their experience and the fact that we are seeing more. But it is, you're asking somebody in that moment, to either hurt or be hurt, to kill or be killed.
Generally, it's a matter of life or death, not and death.
Correct.
Councillor Lee?
Thank you. I'm trying to figure out here, how many CEWs do we have currently?
About 500 or so in our inventory.
500, so we are doubling it with an additional 400.
Correct.
And at any one time, some of them will be charging or, because it does lose its battery power.
Yeah,
So, by the addition of this, I would say at any one time, there's going to be 600 to 700 out there.
No, that would be in our inventory. Again, it would depend on how many officers are working that have the ministry-approved training, who would be taking it out.
And second question I have is that would you classify the CWs in your lethal weapon classification?
Less
Same
lethal.
with the firearm?
Less lethal.
So the way the officer would be handling is that we'll go through the same kind of logic to do the escalation and everything. And then it's only when they have to either use the CW or the firearm, then they have to make a decision and which one they use.
When the officer is facing an imminent threat, being someone has the means, the opportunity, and the motive to carry out that threat, that's the decision point. That's when they can use it.
Thank you.
Councillor Carroll?
Yes. So if we were contemplating a pilot, Yakabuchi contemplates a pilot and goes to great lengths to talk about the types of data that we should be looking at. We in our group draft of the motion, the one that is not the one we missed, the clause we missed putting in, I'm going to add it in later, is. And I think this is really the community's concern, is whether or not the use of force overall increases. So what they're looking at is does the drawing of a lethal weapon stay the same? The use of a baton goes down and CEWs move in, and then you have an overall increased use of weapons. So he's asking us to look at that overall increase, and I'll put that in a motion later. But I'm wondering if in coming forward now with this detailed report, and in all the time since the police board years back responded to the community and said no, have we been tracking other police forces? Do we know if that is a trend that has been looked at in other jurisdictions? And has there been any attempt, I guess it would have to be an academic attempt, to try and do apples to apples for us? You might see, just counting the deployment of a CEW would not give us the right statistic if we're looking at, say, a European police force that does not have lethal weapons, but they have CEWs. Are they using them more overall than we're using both lethal and less lethal weapons? Has anybody unpacked the data that is available when you start to look at the various monthly statistics in different types of police forces?
I don't know if we've looked at that, but I have, through the team that I'm working with, actually done some canvassing nationally and internationally. I can tell you, particularly with Scotland, and I mentioned it, I think, in my presentation, or might have mentioned it, that, in fact, Scotland is actually moving toward issuing their frontline CEWs. They're going to issue 500 by the end of May, with the plans to roll out CEWs to their entire service, because they are seeing some of the things that some of the things that I've seen in my data for the officers' occupational health and safety. They are seeing more assaults on their officers. We saw a spike last year, and they are using that as a less lethal option for them to address some of the threats that they're seeing. And while it's informative to look elsewhere, I've presented today the Toronto experience. So I don't know how much more relevant the experience can be within the Toronto context, in the Toronto environment, in our workplace. And it has proven to be less injurious.
I'm just looking at unpacking the data. Because while I appreciate, I appreciate we have to be concerned about assaults on officers, but if the reason for asking for the CEWs is because of assaults on officers, then I can go right ahead and anticipate increased use of force. Because what are they doing now? If someone is threatening to assault an officer, they have either lethal force or de-escalation. If the reason that they want the CEWs is because there's an uptick in assault or attempted assault on officer, either one, then I can predict an increased use of force. So how are we going to track this? we're looking at a financial implication if we adopt the recommendations here today of 400 weapons. The financial impact is listed as 950. What does that entail? Does that entail monitoring? Does it entail data analysis? If we're sort of rolling this out in a pilot basis in certain areas, does this cost include the types of actions that will have to happen to report back to us?
Yes, so let's be clear. This tool is to achieve 0 deaths. So when you asked about some international comparisons, I brought up Scotland as to terms of what they're doing. But in terms of the monitoring, the tool is downloaded, so the data is downloaded. It's reviewed by a supervisor, the person's supervisor, unit commander, our use of force analyst. They look at it for breaches of law, of training, of governance. We have a use of force committee that's going to look at all of the
And they
application of
already
force.
exist, so
Yeah,
that's
they
not an
exist.
additional cost.
Exactly.
They'll have an additional volume.
Exactly. And in fact, what I've done is added to that committee the staff superintendent of corporate risk management, through whom the college, professional standards, governance, legal report, to be a member of that committee as well.
Okay, Mr. Chair, the chief wants to respond as well.
Chief Saunders, yeah.
Thank you, Chair. I just want to clarify and make sure we're getting this correct. I don't want us to get trapped in an either-or scenario, because the range and magnitude of the situations that our frontline men and women are put through are incredibly dynamic and very swift. And so I can just at the top of my head think of scenarios where right now the only option was to use the firearm. When I have A on top of B stabbing them, and my officer does not have a less lethal choice, they have to use the firearm. My officers don't want to use the firearms. They want 0 death. And so when we compel them into the situation because the proper tools are not provided, we wind up in a situation where that public trust factor magnitudes tremendously, and those costs are not just financial. They implicate a lot of other things. So I just want to put that on the table.
Okay.
Carol, did you have more?
Yeah, I did. It was about the training. I went and took the 3 days of training, but I've never seen here in the last few years. I've never seen a true a tracking of what are the ongoing trainings. We do training and full, recertification of certain things, and I've never seen a report here that says, and now all 5,000 officers have taken the training, and now we're going to improve it, and here's the next wave of training. Is that something that's sort of an upon request thing for boards? How would we track if we were to embark on this only on the caveat that de-escalation training increases, is enhanced, it's recommended in Yakabuchi and all the rest. Our board member who couldn't be here, Ms. Mulliner, recommends it. If we do this, what is the regular reporting mechanism for us to know what goes on at the college and when every single person has been through it?
It's a yearly program, starts in January, goes to December. That's the program year. I can tell you in 2017 we trained just over 5,300 officers. There is a board report, I think, that goes to the board in June, I believe, of training. We can add that.
And does it break it down? They've now had because I'm trying to remember, I was struggling because I was relating it to a Yakabuchi recommendation. Could we get it to the point where it breaks down for us, okay, this many people had the unit on regulated interaction, this many had the unit on de-escalation in its classroom component, its simulation, et cetera, this many have had target practice, all of the above. Could we get to the point where we're breaking that down so that we actually know as an oversight board when to say, okay, it would appear you've taken the whole service through this. What changes are you making? Because you're into people coming back for the next view. Could we get it broken down to that extent so that we would know when to say, what are the changes coming up? What new is going into the training?
Yeah, I can certainly, and I tried to do it in my presentation. You saw each each year, things that were added. So the course starts in January, goes to December, and all the officers go through it. And it's not a target practice is one course, and regulated interactions is another. The 3 days is one program. So they move through it throughout the calendar year.
Right, but I think it's important. While the constant theme of do no harm is there, the various components come up in our deliberations as well throughout the year. So I think breaking it down, what happens in a 3-day unit, and which components are changing over time. There was I'll give you an example. This is why I ask. There is a very compelling video that they use that I understand is a real incident. We're looking at body-worn camera footage from somewhere in the States. You'll be well familiar with it. Where de-escalation is used, and in fact, the person that they're trying to calm down doesn't actually fit the bill. He isn't contained. He could turn around and run because he's in the middle of a field, and he is in fact tased, and it doesn't work because he's full of adrenaline and in mental health crisis. And the de-escalation is in the end the only thing that gets to the point where they can then contain him and take him in. It's a very compelling video. So, having seen it, I'd want to know, when has the whole service gone through this? And now that they have, you can't use that next time. What is the next unit going to look like? How are you going to enforce all the ideas that they got from just watching this video and debriefing it? What's the next unit for the next year going to do? I think for the community and the board to have that type of information is really the only way to invest in more force, albeit less lethal. They're going to want to invest in more de-escalation, and they would need the update that it is continuously improving. Would there be a way to build that into the annual report from the college?
Absolutely.
Okay. Those are my only questions. So I'm going to embody that in a couple of add-ons to the motion.
All right, let's hear from Mayor Tory, because he has not had a chance yet. Shoot. Oh, well, you were the last. Okay. Ken, sorry, I'll come to you. The other thing, it's been alluded to several times, but Ms. Mullner, who has an active interest in this issue, I asked her, as you see, to put her thoughts on paper so that they are there. It's been alluded to several times, but I just wanted to draw people's attention to it. Mr. Jeffers, you want to ask some more?
I just wanted to ask one more question. I was at the part of the training at the college there, and they were doing some actual scenarios. And I was really intrigued by one particular scenario where someone was going in a state of crisis, and a psychiatrist was called, and the psychiatrist sort of said, "Well, there's nothing more I can do," right? And so that decision making about when de-escalation is not working, how does that go? Like, in other words, how is that decision made that, well, look, we've tried de-escalating the situation, it's not working, as the psychiatrist gave up, said at the hospital when this was occurring, and so a decision was made. How was that done?
Yeah. So anytime an officer uses de-escalation, again, it's safe and practical to do so. And when it's not working, officers will continue to de-escalate until the subject's behavior moves into an imminent threat. So they will de-escalate, whether it's containment, whether it is other attempts, verbal, nonverbal strategies. So they will continue to do it until the subject poses an imminent threat to themselves. Sometimes it's themselves. Sometimes they'll hold a very large piece of glass to their neck. They'll have a knife that they will be threatening to impale themselves with, or they will threaten to harm someone else. So it's the actions of the person that directs our officers. And as I mentioned in my presentation, we're actually teaching our officers how their actions or inactions can help manage the imminence and the outcomes that we want, the zero death. And then the decision's made.
If not, we're waiting for...
I just have...
Mayor Tory? Thank you.
Sorry, I was just... first of all, can I ask, because what I wanted to talk to Councillor Carroll about was, the tradition has been, by established policy going way back, that there be an annual report on the use of CEWs. And I think in light of the numbers that we've seen in this report and in your presentation today, which I thought was quite thorough, that the numbers are such you could divide them by 4 and still have a substantive report. In other words, if it was, a handful of occurrences, you wouldn't have much of a report. But I just wanted to sort of make sure you believed it was practical, because I have encouraged her to encourage you, or to request of you that you, if this is approved, that you report quarterly, especially if we're looking at it as something that is an evolution in the deployment of these, so that we're now deploying substantially more. It's a good reason to stay more on top of the numbers than an annual report, which quite frankly then comes well after the end of the year. So you'd get 2018's numbers, sometime next spring. And I think that if we're watching this carefully, which I think Councillor Carroll's motion we're about to see contemplates, that a quarterly report would be better. And I just wanted to make sure that wasn't impractical, because I strongly believe that would be a better thing in terms of accountability for all of us.
And just to respond to that, I definitely take the concerns of the community very seriously with respect to offering another option for our officers in our suite of options when it comes to trying to reduce any harm in any way, shape, or form. So I would encourage that and understand that our accountability should be higher for a period of time. I would just request that there is a time frame within that we can, after a period of time, expand or expand the duration of time frame for that report back, because you're correct, sir, in the sense that it will involve a lot of work, but I understand it, and I think that it is important for the accountability factor.
Yeah, I think in the context of the questions asked earlier, I forget by who, but one of our colleagues, that there's going to be rigorous assessment of this. Certainly, I would want to see that done to make sure that if it's proved that, that if it's not working, and whatever that means, I mean, certainly we're looking to save lives and bring that down to 0 here, that, you would be able to take steps, but you have to do that based on facts. I'd just like to ask one more question, Mr. Chair, again, of the Chief, if I could. It was suggested earlier on, and I think it was even suggested in Mr. Akibuchi's report, that there be an accompaniment of body-worn cameras with CEWs. And I just wondered, again, because you haven't reached final decisions on body-worn cameras and how that's going to work yet, and the CEWs is yet to be exactly determined, but are you willing to consider, as part of your deployment of body-worn cameras, the option, as suggested by him, of taking into account in your deployment of body-worn cameras those who end up having CEWs? Just because I think it actually is not a bad, combination in order to allow us again to have greater accountability is the objective in the end that every officer will have a body-worn camera?
That is the anticipated objective, and written within the procedure in our pilot, it was very clear that if an officer is going to be in contact with a member of the public for any type of interaction, that those interactions be recorded. So it would marry up to, of course, if the call comes across as there is going to be a situation where there may be potential use of taser, I would say that the expectations are that the body-worn cameras would be part of being turned on for that process.
Thank you.
Any other questions, Mr. Jeffers?
In looking at the, I know there's a procedure when a weapon is drawn and so forth. In this particular case, with the CEWs, would we get a profile of the victims of, or those who have been subject to the CEWs, profile based on race, mental health, stability, that sort of thing?
Right now, when we report to the board on our CEW use, we report on whether the officer felt that there was a mental health issue at the time. This is the officer's perceptions.
Right.
It doesn't report on whether the person was admitted after the call.
Mm. And so the race-based statistics that we talked about, and there was a motion by Shirley Carroll, that would be part of the whole scenario with NICE?
It could be. I can tell you I've had some conversations with those at the Anti-Racism Directorate, And they are in the process of identifying a standard for race-based statistics collection as well as the analysis of it. They were very clear to me that it's not just the collection of the information, but the analysis of the information as well. So all government ministries right now are actually waiting for that work to be done.
Thanks. Mr. Chair, you know, I know that we have the committees on anti-racism committee that's being worked on, as well as the mental health committee. So that would be a degree of oversight for us to want it to be.
Any other comments or questions? This is like third time, fourth time?
Yeah, I obviously have a lot to say on this
Yes,
subject.
no, because I'm just waiting to get my own say.
And just so we're clear, I've done a lot of work and research on the impact of CWs on people in crisis over my career. So I'm not opposed to CWs. I think given the option, anyone would rather be tased than be shot at with a gun. Even though CW may be less lethal than a gun, it's still a weapon, and it has to be used as an absolute last resort. So Justice Ikebuchi, more than anyone, saw that and was very cautious in his recommendations. He recommended that there be a pilot project in place, that it would only be expanded to a certain group of frontline officers first, and then what we've discussed already around body-worn cameras. And he stated that that would actually increase accountability and transparency and trust with people in crisis. And I wholeheartedly agree with that. I think the service has done a lot of work over the years to engage the mental health subcommittee to build that trust. I think moving in this direction is going to lose a lot of trust with the mental health community. And especially today, we've received many written submissions from very reputable healthcare organizations in the city cautioning us against this. So Center for Addiction and Mental Health, Canadian Mental Health Association, Schizophrenia Society, who's here today, as well as the Empowerment Council, which, as you know, is a collective of consumer survivors. And also, let's not forget, back in October, the Human Rights Commission also cautioned us against this. And Justice Ikebuchi's recommendations, they weren't meant to be cherry-picked one by one. They were not meant to be looked at in isolation. He intended for it all to be implemented. And I am not convinced at this moment that we've exhausted all other options. So I cannot ignore the recommendations from Justice Ikebuchi, and I especially can't ignore the advice that we received from healthcare professionals, as well as community members who are here today and in the written responses. And as well, Marie's not here today, but she also felt very strongly about this enough to put her thoughts down into a statement. So given all this raised, I can't support this proposal. I would definitely rather see the funds used to expand MCITs instead.
My final comment, excuse me, this, I mean, I've had personal experience with lethal force as opposed with both here in the United States and here, and with all of that, and having experienced that with friends who have been victims of lethal force. The discussions that I've held, especially in this Black History Month, are long been with, would they be alive today? And for me, this is a question of, my preference is for them to have a 99% minimum chance of being alive with the use of a CEW rather than with, lethal force. So, you know, it's logically, for me, it sounds like, you know, de-escalation as an option. I mean, I support de-escalation all the way, but I know there's a moment in which de-escalation doesn't work, having experienced it personally, because people are not hearing, and all of that, and consequences are not part of your thought, right? And I think that, Mr. Chair, that this is an opportunity, when I say it's either life or death, and this is part of my commitment to this.
Thank you, Ken. Chief Saunders?
Well, first off, I do want to thank Deputy McLean and her team for a very comprehensive review. This review goes back many, many years. And so, in essence, I think we've moved beyond the pilot conversation based on what is presented. And I do agree with members of the board where we talk about cherry picking and not doing that, which I really do think when we look at the report that was submitted as well as the presentation in recognition of JKE and an inquest based on chief coroner's responses, based on chief pathologist responses, based on ministry responses, based on Justice Yakabuchi, which is included in this, we have made, I think, a very comprehensive study and definitely did not consider cherry picking to come to the conclusions that we've reached. I just wanted to clarify that.
Okay, I've just got a few comments, and then Mayor Tory is writing something. Yes, I've been on the board for a while, and I sat on the original discussions maybe 4 years ago, Joanne. We had 6 or 7 hours of depositions. I've looked at and been concerned about every time we've had a coroner's report. I would argue that, you know, when we came forward and we did because it was the board that insisted that we do a review again the same way we did before, a public consultation and hearing. We did that. We thought there was more that needed to be done, so we asked you to go back and come back with more study, more thought, answered more questions. This is a very, very complex issue. I fully recognize the bodies that have come forward with recommendations. I fully recognize the difference of opinion as to how we can go about it. I guess I would argue in part that by having the supervisors use the conducted energy weapons for the period of time they have, that in itself is something that we've learned a great deal from. Not exactly a pilot project, but de facto to some degree. I think the accountability that's going to be suggested here going forward, that quarterly reporting during the period of implementation is the control to see how it's going, not to wait for a year to find out that there were problems that we didn't deal with. So I fully recognize, and as you know, I encouraged Ms. Mulliner, who couldn't be here, to write out her thoughts so that we had a full feeling and discussion on the board. But I do think we've had a very long, fulsome discussion. I recognize that Frank Yakabuchi's request or suggestion of body cams, it makes sense. I think we all agree with that. Unfortunately, these things are you can't tie them completely together and can't necessarily wait for one for the other. As we'll find out as we get into it next year, the body cams have their own unique challenges and expenses. So, you know, anything we decide here is, there's some people going to be disappointed. But I first of all echo the chief's thanks to all the work you guys have done, because we have kept coming back and back and back and back at you for more information. Second of all, I want to say to the people from the public who have taken the time to make depositions, we've listened long and hard. We've done we've gone back with those questions behind the scenes to the service, but ultimately it comes down to a very difficult decision. So I want to thank everybody for their engagement. And Mayor Tory, you've been writing something out. Have you got a recommendation, or is Councillor Carroll?
I think Councillor Carroll will do that, and I'm happy to speak now, and she can then move for the other motion. Yeah. Mr. Chair, I just want to concur in your comments. First of all, concur in your comments in thanking everybody, including all those who've written and deputed today. I mean, these are, one thing you learn in having these jobs on the Police Services Board or in public life is that these choices are often difficult and very complicated, and there is no kind of completely right answer. So you just have to seek an answer you think is best in the circumstances. And I think we've heard the police say today, and I've always sort of believed that this was their modus operandi, and all of their training is to try and safely and peacefully resolve every situation, ideally without the use of any kind of force whatsoever, and use words and use other things to de-escalate situations. And that's always preferred, and it's clearly used the vast majority of the time. If you look at the literally hundreds of thousands, in fact I guess millions of calls that are undertaken each year, it's obvious that the vast majority of them must be resolved in a manner that is without the use of any kind of force whatsoever, because we see the numbers of instances where the opposite is the case. And the objective here that the deputy put up on board right at the beginning was to get us down to 0 deaths, and I'm sure that you could go a step further and say that the objective should ultimately, and I'm sure ultimately is, to get it down to 0 instances in which anybody ever deploys any of those tools that were up on the board, if that was possible. But I'm very I'm struck by the fact, and it was one of the numbers I remember when I first heard it, I almost thought it must be the wrong number, that the number of instances in which today either the CEW with its limited deployment or firearms are used at all is tiny as a percentage of the overall even number of arrests, let alone encounters with people, and that's as it should be. But again, last year, just to look at the numbers, the number of instances in which a firearm was used was a total of 6 times. In a city of 3 million people and with hundreds of thousands of contacts with the police and of arrests and millions of encounters. And last year, the number was, for the first time since 2010, the number that it should be in terms of the number of people who died as a result of that use of firearms, which was zero. And so I think the objective obviously has to be to keep that number at 0 and keep the number at 0 of deaths in encounters with the police for any reason whatsoever. But to me, the best way in which you're going to sort of find the most solid place to start is to bring the number of uses of firearms down to 0. And I think that substantially enhances the chances, as was the case last year, that you're going to have 0 deaths. Because to me, this is all about saving lives. And I am going to support this. I'm going to support it on the basis of what Councillor Carroll has done a lot of work on, including going out, and I thank her for the fact she went out and saw the training and spent quite a lot of time looking at the training to try and satisfy herself, and hopefully through that to satisfy us, that the training was as good as we'd been told it was, but also that it gave her the opportunity to talk about enhancements that could be made to that we can add to the motion that will be put to approve this today. And I just think that when we saw earlier on those categories of threat that exist, that when you get down to the threat that I think was described as an imminent threat of death or harm, including self-harm to people who are in crisis, that anything we can add to those very few cases where we actually do this. And I was struck by the fact that the deputy mentioned a couple of times in her presentation that of the times when tasers are deployed, half of that number is actually where it's just shown to somebody and it has the desired effect. So even half of the numbers are instances where it's just shown to someone, and that actually then causes people to comply with whatever they're being asked to do in terms of a peaceful resolution to something. And I'm supporting this on the basis that the CEWs not only represent that less lethal use of force than the ultimate weapon or tool that is in the range that police officers have available to them, namely a firearm, but also that it's going to be subject to the different kinds of conditions, including what I think is an improved reporting condition, which the chief has agreed to for this period of time. And I view this as maybe phase 2 of what in effect has been a pilot project. It wasn't called that. But if you look at the limited kind of deployment that's happened with supervisors, it's had a number of these CEWs out there, and we have a lot of knowledge that we've learned from that, and a lot of things I'm sure we've gained in terms of training and so forth. And this will be a further deployment of the same thing, and I would maybe call it a phase 2 of a project to deploy these, and we will learn from it. And we will learn because we're going to have quarterly reports. We will learn because of some of the things that are in Councillor Carroll's motion. I just will conclude by saying this. If it's about saving lives, I don't have any doubt whatsoever, just as one person, just as a person, let alone as a police board member or as the mayor, I don't have any doubt that I could name 2 or 3 people right now from what I've read, and I don't know anything more than average people know from reading and watching the media. There are people we could name today who would be alive if there was a greater deployment of tasers. And I look at it very much the same way as I've looked at an issue that I had to struggle with a little bit personally, because you do struggle with these issues when you're in these positions where you make the decisions. And that is the issue of supervised injection sites. And I've had some very interesting discussions with people who are very concerned about those, and including at least one journalist. And I sort of said, look, for me, when it comes down to sort of saying that by having a supervised injection site, if that stops one person who's a very troubled person that has an addiction issue from losing their life in an alleyway somewhere by themselves because there was no one there, because there was no supervision, because there weren't clean needles, then to me, that is something that we better take a pretty serious look at doing, which we have done. And the same here. To me, if there's a person that we could name from the past or a person in the future whose life will be saved, and by the way, that's the most important thing, but also you'll avoid as much of the trauma as our police officers have to face. And I know because I've talked to a lot of police officers, including ones that I'm with all the time, about the notion that nobody that goes into police work ever wants to pull out any of their weapons. They would like to get through their entire career without ever taking their weapons out of any kind, any of these things that we've talked about today. And if you accept that to be the case, then I think that in this case, what you will stop is somebody from losing their life going forward, even with these smallish numbers. And to me, that's what we're here to do. That's what they're here to do, and that's what we're here to do. And so that's why I think this is the right thing to do, and I will support it.
Councillor Carroll, last word to you.
Even at the last minute, there were a couple of changes here, so I don't know if clerks are able to put it up with changes. As Mayor Tory did, as Ms. Chandrasekhar did, as everyone on the board has struggled with this to the degree that everyone on the board has had input into this motion. It really is a group effort. It does actually, the board is recommending the introduction of the 400 additional CEWs. But what it does, if you don't want me to read the whole thing, it will, I think providing it will be the easier thing. What it does do is enhance some of the things already contemplated by the service in the report. And most of them, to Mr. Sewell's point, in our motion, we return to Yakabuchi. And lined up where, while they didn't name Justice Yakabuchi, in fact, the services report has to do with it. There are accountability measures here that come out of Yakabuchi. There is a time problem between CEWs and body-worn cameras. But I hope that the service hears today that whatever our issues are with BWC procurement, it's got to happen sooner rather than later. Because as a result of discussing the CEWs, the community will go back to their concern that those be deployed wherever someone is now carrying multiple use of force mechanisms. What is important, I think, is if we scroll down onto, there's Clause 2, and then Clause 3 is where there are some important changes. We do currently get statistics on CEWs annually. And I know that the service has palpitations when we bump something up and say, we'd like to hear about that quarterly. It's always concerning. But we have to remember that when we're in a situation that is new, we're trying something new and it's maybe not stable, we need quarterly reporting to provide appropriate community oversight. It doesn't mean that you can't go back to annual. When the time comes. So what we've done here is said that as part of the next quarterly report, because we would like to change to quarterly reporting on CEW use, that what we've done is input some of the components having to do with MCITs. Let me see, which clause is it in there? Yes, Clause A, input from MCIT members with respect to any proposed changes to that program in light of the expansion of use. If we're going to continue to advocate for the increased number of intervention teams, we should of course be engaging to the max with those that we have, so that if we increase their number, we're also improving on that program. There, the discussion, I think the chief is right. Yakabuchi said, why can't the MCIT be primary, not secondary? He didn't mean that they should respond and actually interact with bad guys before police officers are there. I think what he's saying is, if on the phone you already know that the person you're going to respond to is a person in a mental health crisis, why do you have to wait till you get there and lose precious minutes before you call them? Could they not co-respond with the first responders? I think what he was getting at, if I had to guess, but I know that I would certainly be comfortable with that. I don't want to put them in danger. I know that the police officers have to keep the MCIT safe, but they need them there sooner rather than later. What's important here is if you go down to D, I'm considering a lot of this read, but if you go down to D, the analysis points there are word for word verbatim what Yakabuchi asks us to track if we're going to expand the use. They are his idea of, if you start to pilot this out to more officers, this is the data you've got to collect. And it was just an oversight, but I hand wrote it back in, whether the force overall increases as a result of expanded availability of CEWs. And that's important. I don't think there's anyone in this room that would have any terrible regret if a CEW was used instead of a gun. But if a CEW is used instead of de-escalation, that's why you're in this room, and that's why you made your deputation. So here's all I'll say about that. Here's what I got from my training. I had my executive assistant, Ms. Tepper, who's back at City Hall right now, is a master's in social work. So she was looking at it through her lens, and I was looking at it through mine, teaching techniques and the rest. What's the comfort level of the officers in the room? And that sort of escalates through the 3 days. They're sort of pushed into new situations. From the safe space, they start by just answering using clickers. You're in a safe space. No answer is dumb. Everybody needs to start engaging an answer to now we're answering, now we're testing each other, and so on and so on. And that was an impressive technique to me. But my aha moment that the community conversation about de-escalation, the degree to which people in the community now understand that there's a thing called de-escalation, the police use every day and need to use it more. I think officers are aware of it. In the catwalk simulation scenarios, it's probably what happens. It almost becomes social because there was a big classroom being taken through this training. And so they had to go through 5 scenarios in order for every officer to go through a scenario. So there were 5 different things. The rest of the officers watch on a catwalk how he handles it. And they were all de-escalation situations. And they watched them all. And the first one, we were all watching with rapt attention. And we watched the incident, how he handled it. We watched the debrief where the training officer said, okay, why did you say that? And how did you contain him? And was he an imminent threat? How did you make that decision so fast? So they do the big debrief. We had to do that 5 times, 5 different scenarios. So as happens, as is human nature, people became sort of desensitized to it. So we were all starting to get pretty chatty up on that catwalk. The final scenario was a no way out scenario. De-escalation wasn't working. The person had a baby in their arms, and the officer had to do what he had to do. And when he put the baby down, but was not giving the baby up and was charging the officer, it was a perfect scenario of there's no choice here. And when the officer deployed his weapon, it's a training weapon, but the degree to which every officer was sort of traumatized for a moment, deathly silence, and now all 30 people in the room just froze and began to rack their brain every minute of what happened. Now, what happened? Why did he have to do that? Oh my God, a weapon's been deployed. It became clear to me how serious it is to them when they do that. And I realized they really don't want to deploy their weapons. They don't want to do it. And when it does happen, it is a big traumatizing deal for every single one of them. Some of them, I thought, are some of these officers people who've been through this in real life. They've been at a shooting, and that's why this is happening. It was a very powerful moment for me. And I was, right up until that moment, still saying, I really don't want to do this CEW thing. But even in that scenario, I realized you could have used a CEW on that dad, and he would not have had to die. He was in a big mental health crisis. And a CEW would have meant that that person was alive. And I thought, I'm only looking at in simulation. An officer, the reason they're asking for them is they've been in that situation in real life. That's hard for me to say no to. I do need all these caveats. I do need all of these added clauses because we have to analyze and monitor the heck out of this. We must. The other thing I want, this is my usual soapbox. of plain language. We do get an annual report on the college, and it actually does tell us how many officers have went through de-escalation training, but nowhere in the chart do you see the word de-escalation, because we love our abbreviations around here. So Joanne showed it to me. In plain language, when we get that annual college report, I made it an extra clause 4. I don't think Carlene's even had time to type it. That we also start in that report, we actually hive it out and describe it to us. And that there's a reason for do this. No, we made it an E. That annually we get the number of officers who've received the 3-day de-escalation training in the last 12 months, and that be reported on annually. And I want it to be highlighted that it's the de-escalation update, because I think what that will do is jog the board, and future boards thereafter, I think, should be jogged. Oh, okay, the de-escalation rate. Wow, 4,000 officers have been through this now. I hope what that does is jog future boards to say, okay, what are you doing to continuously improve it? What are they going to see next year? You got to take 4,000 officers through it right now. What was the most successful part? What feedback did you get that this was a powerful part of the training? And how are you going to one-up it again and again and again so that the training does continuously improve and remains the valuable 3-day session that it is? That for me is the counterbalance to taking this difficult step. Those are my remarks, and here's our long group motion.
Thank you. Chief Saunders, you had something, and then Mayor Tory has one more thing he wants to add, and then we'll...
If you want to go first, Mayor?
Okay.
Well, in my case, I apologize. I had been meaning to just add this on to, and I thought it was already incorporated into Councillor Carroll's motion, and it was just to give me the board's approval to approach. I'm in discussions already with both the Minister of Health and the Minister of Housing, specifically about mental health related issues, more on the housing side. And this is something that I think I should add to my agenda, but it would help me to say that the board approved my approaching them to say, look, one of the things we need is an expansion, because you made a very polite reference in your remarks, Deputy, about the fact that the very first thing you talked about, the first thing we try to deploy, the MCIT, is yes, deployed across the city, but not every hour, every day, and there's nurses sometimes not available, and so forth and so on. And I would like to see if we can get him to commit, the government, to fund that in a more complete manner, whether it's for us and other cities. Toronto is what I care about, and I think it would be just helpful if I had that added on, and I think Councillor Carroll won't have a problem with that, just to sort of give me the board's support in going to see him.
I think that's great. Chief Saunders?
Thank you, Chair. I want to make sure that we do get this right, and I do appreciate the extensive detail behind the asks. I want to look at 3D sub I, and I think it's important if we take it in just that wording. I've got some concerns. I think that there need to be some 3DI. Whether they're used more frequently, I'm going to anticipate that will be the case, but there needs to be correlation with respect to injuries to people that we're apprehending, injuries to officers, and that needs to be, I think, put in a tighter context, because that alone, I don't think is necessarily the right measure. Well, I think if there is some further exploration based on some of the, there we go. Yeah, so it just says whether CWs are used more frequently by primary respond units as compared to baseline information on current use of CWs by supervisors. If we're saying that this is going to reduce injuries, I think that needs to be factored in as well, so that
Take a minute, because Councillor Lee has a concern, I think, that he wants to raise. So why don't you take a minute to script, and we'll hear from all of our colleagues. Councillor Lee, do you want to speak to something? And then Mr. Jeffers?
Yes, thank you very much, Chair. Can you also, I'd like a friendly amendment to point 2 and change it to whether CEWs are used more frequently and not misused. I mean, the wording there it seems to indicate that they are doing wrongly. I mean, it's total use. It's not point 2 under D. Next line down. Yeah, identical, yeah. See where your cursor is, just move over to the left side.
And you just combine them?
Put it as used more frequently rather than misused. I think change all the misuse to users.
Well, but the problem is that makes one the same as two, and there is incidents of the misuse of tasers in the world. It has happened.
Yeah, but
Not often, but it has
but
happened.
that
So I think what Yakabuchi was getting at is if people start to have to be disciplined for the way they have deployed a CW, you're going to want to start to track it.
Colleagues, this is the 1 and 2 are very similar, and the chief has comments on one. Have you scripted yourself here at this stage? Yeah. What would you recommend?
No, I'm fine with it right now because one does nullify the other. What you're looking for is misuse, and are we not practicing what we preach when it comes to de-escalation, all of those things? And so other elements give us the opportunity to explain. So I'm fine with it.
Point 1?
Yes, I am.
Thank you. Mr. Jeffers?
Yeah, I'm just addressing the 3B, where I know that a lot of the members of the black community would be very concerned that if there's a specific reference, because when you look at all of the protests that have been happening over the years, it's primarily, and there will be concern and fear that there will be a disproportionate use. I'm wondering if, I know the human rights, and that's good, it's covered a lot of areas, but I think that a reassurance on specifically with
as I said, the members of the black community would be, I think, a gesture of understanding and sensitivity to the disproportionate number. If
I think, we're really dealing around the mental health issue. I understand what you're saying. I think, Indigenous could say the same thing. I just, we parse it perhaps too much, but colleagues, I throw it open for your comments.
I just want to clear, do you mean initially or quarterly?
the quarterly report, as that's what I was mentioning earlier on, yeah.
Quarterly report.
Yeah.
We're adding bigger and bigger bodies to it, then the ability to report quarterly goes down. So I'm wondering if they could be captured and input, I'm wondering if they could be captured and input gathered from by just looking at consumer survivor groups. Because if you want them to be revisited every quarter, you're starting to make it a pretty big group.
I don't think so. As I said, this is a reality that we're faced with. And in looking at that, that was the first thing, one of the things that came to mind. And it doesn't say that one is more important than the other. I'm just saying that there's a reality of resistance.
Ken, is there a better way to approach it, and that is to ask the steering committee, the local committee, to address this, because they're going to be coming back and advising on all aspects of excellence in anti-black racism and understanding the issues, et cetera.
Yeah,
I think it's
the city has
perhaps more,
recognized it. The mayor
it's
has.
more appropriate under that than it is under this.
I just think if it's true that we picked up exactly the wording out of Mr. Justice Yakabuchi's report in framing this out, my guess is, knowing him a bit as I do, that he deliberately chose not to notwithstanding the fact that I understand what you're saying, historically there's been a disproportionate number of black Canadians who have been, subject to some of these circumstances, that he chose not to do that because it would ignite another discussion about, well, does that mean that somehow looking at one group is more important than looking at another? I mean, I think the bottom line here is for us to be looking at all consumer survivor groups, all experts in all kinds of human rights and mental health with respect to the impact of the expansion of CEWs on the lives of people with lived experience. So to me, he deliberately meant to cover everybody without starting to sort of say, but we should have a special look at these groups. And I think we should just take it as taken and even record it in our record of the meeting, the fact that you raised the point, because I think it's a very valid point, and I think the chair is right, that the best place to have a detailed look at this in their own deliberations is with the new committee that we've set up specifically to address all instances of any kind of harm or discrimination that is specifically experienced by the Black community in respect of policing.
So, colleagues, long and extensive discussions. I think what we need to do now is, if there's no more additions, put it to a vote, and what we need to do
Well,
is receive.
I'm just wondering if there's one more thing to add.
May I sketch out what we do first, and
Okay,
then you can
okay.
say that, what about, and that is we need to first, I think, receive our colleague Marie Molyneux's letter to me. Second, we need to approve the recommendation, the report delivered by Deputy McLean and her team, and amend to it and approve at the same time the motion that we settle on that you've kicked off and we've discussed. If you've got anything else to add before we get to that, please do so.
Well, I was just wondering if in order to pick up Ken's point, we want to add that the board asks the advisory committee, Notitious Advisory Committee, to consider adding to their terms of reference examination of the disproportionate use of force, so that they're looking at it, and that would then compel them to also be tracking the CEW data and addressing it inside the anti-Black racism advisory committee that comes back to the board.
Mr. Chair, if we simply added the words in here, input from consumer survivor groups, experts in human rights and mental health, including, and what do we call the committee? It's called, pardon me? Doesn't have a name. Including the board's anti-racism committee. And then I think that, right? And that sort of covers it off.
So, colleagues, we've discussed it. Councillor Carroll, first of all, let me have a motion to receive Ms. Molyneux's. Yes, we can. We're doing that. So, well, I was actually going to put receive the report and the this together, but Marie's separately. So, if you want them all three separately, say so.
Yes, and I would appreciate if the four clauses could be voted on separately. Because there are four separate. Not the ABCs, but the 1, 2, 3, 4. Yeah.
Although, not to complicate your life.
Yeah, I think let's vote on all three. And I don't want to separate the motion. No, I understand.
Board has a right to ask for ad seriatim.
I understand, but I'm just throwing it out. I would prefer to have the three together. I'm happy to take Ms. Molyneux's, I'm happy to take the report, and I'm happy to take the recommendation. All wrapped together in the amendment to this. So I throw it open to colleagues again.
Do we use Robert's rules as a default or just our own bylaw?
Yes, it is.
Because under Robert's rules, if you want ad seriatim, there's no debate. There's no debate to that. A member can ask for ad seriatim.
Okay, so is that, but, okay. Okay, that's fine then. Okay. So, first of all, may we have a motion to receive Ms. Molyneux's letter, Councillor Lee, seconded Councillor Carroll. Second, may we have a motion then to receive to approve the staff report, Councillor Carroll, Councillor Lee, and third then, will we take each of the motion overall, but let's vote on each of the, can we see them properly? So, and who's moving this? Counselor Carroll? So you move, you're going to move each of them? Yeah, okay. 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 So moved by Counselor Carroll, seconded. Counselor Lee, all in favor? Clause 1 we're voting on?
Wait, are you guys doing a recorded vote, or?
No, no. Okay.
Yeah, my objection is to this.
It is to, it is to 1. Okay. So, all in favor of clause 1? All in favor of clause 1? Okay. So that's recorded that all opposed? No, she was slow getting her hand down.
Just calling out our names as they write your votes down. I didn't hear my name, so my.
Yeah, okay. So, clause 2, all in favor? Any contrary? Okay, that's carried unanimously. Clause 3, all in favor? Any contrary? That's carried unanimously. Clause 4, all in favor? Ken, are you all in favor? You gotta raise your hand. Any contrary? So that's carried unanimously. So it is 1 dissenting vote on clause 1. They're all proposed by, it's all proposed by Councillor Carroll and seconded by Councillor Lee. Any further discussion? Okay. Thank you, everybody, very much. A very long and difficult discussion. Deputy McLean, thank you. Chief, thank you. We've got the rest of the meeting to get on with. The next item on the agenda is item number 8, but Councillor Lee, may I turn the chair over to you at this stage? Councillor Lee, may I turn the chair over to you at this stage? He's gone to the washroom. Thank you. Oh, thanks. Can you put that back up on my desk afterwards? Okay, thanks.
We're at item 8, and there are 2 deputations. Here's your deputation list here. So we're at item 8.
Item 8 then. Okay. Thank you. Hang on for a second. Yes, we lost quorum. Yeah. We need quorum. There's only 3. Andy is leaving, so. Yeah. Yeah. They're coming back. Yeah.
I believe the, can you show them?
I can't separate it. I have to send you the entire document.
What do you mean, like the report as well? Okay.
Because I don't have time to separate it right
Like
now.
like the PowerPoint? Oh, oh, one big. Okay. The other thing was I could just screenshot it, like I could do. Media.
Okay, I think we have quorum again. So, so while Mr. Jeffers is coming back, I'd like to call the next applicant to come up to the podium, please. Brenda Ross on item 8, the way forward, fourth quarterly implementation update. Hello, Ms. Ross. Yeah, I just, you know the rules. Please proceed when you're ready.
Could you please pass those out for me? Thank you so much. I'm sure you're all tired. I know I am. I do, however, want to make a comment about item number 8, the way forward. Page 4, the bottom of the page, culture change. I do not believe that you are on the same page as the people that you command. A glaring example of this would
I'd
be...
like to caution that we should be not specific about naming anybody when you're in your
No, I know.
deputation. Okay,
Yes,
thank
don't
you.
worry. No one's names will be used. A glaring example of this would be the police union holding a vote as to whether or not the force has confidence in our chief. The demonstration at 40 College Street on Family Day by police family members is another example of this. I'm very concerned about the disconnect between the police board, the police union, and the public. There seems to be also in this report a reliance on the neighborhood officers that will be chosen to go through the neighborhood in the hopes that there will be a new relationship between the police and the public. And so my comment in part is the handout that I've given you. I've given you a hard copy of the item that I wanted to give you last month. You have a hard copy regarding a certain division that is named at the top of the pages. I'm not naming any police names, but I've also given you 2 police reports. Literally within a few days, 3 officers got in trouble from the same division. 2 different officers from the same division are on trial before the tribunal, and I've also made a complaint that I've included. Now, this disturbs me greatly because we're talking about cultural change, and there doesn't seem to be any cultural change that I can see at this particular division. I only talk about a particular division because I don't really know what's going on anywhere else. Excuse me. The newspapers are constantly filled with problems regarding the police, and this continues on a daily basis. The Toronto Sun, the Toronto Star, it's just filled with problems about things that have happened regarding the police. So somewhere there's been a disconnect between the force itself, the police board, and the police union. I think that this is very problematic, and it's being ignored. We have officers accused of very serious crimes, and we seem to be ignoring what is going on. And despite deputants coming here and we talk about all these different communities that have complaints about the police, we don't seem to be solving the problems that the Way Forward promised to do. And in fact, one of the major things that the Way Forward promised to do was to give us certain kind of neighborhood officers. And so you can see from what I've given you in front of you, we have a group of neighborhood officers in serious, serious trouble. Before we had those neighborhood officers in trouble, we had another neighborhood officer in trouble. But yet we were told these people are chosen specifically for their character. Where's their character? I'd like to know. And when is someone going to pay attention to what is transpiring and do something about it? We've been talking and talking about the way forward, but I don't see us going forward. I don't see anybody going forward anywhere. I cannot believe and haven't gotten over the trauma of listening to my radio and hearing that people were standing outside to take on an argument with the chief. I would have called the chief's office and said, I'd like an appointment. Why were people thinking that the only way to talk to our chief was not to come to the police board, not to call and make an appointment, not to send him a letter, but to stand outside and physically confront him? I'm disturbed by that. I'm very disturbed by that. Now, I feel that the way forward has gone off the tracks. Pretend the way forward is a train. It's gone off the tracks. Somebody needs to reassess the problems that people are bringing to the board as regards the way forward and think about what have we done that might be wrong. What have you said or done that
You have
needs
half a minute.
correction? So I think there is a problem with this feeling of the force has a certain feeling of entitlement, and I don't feel that the board recognizes or management command recognizes their strong feelings of entitlement and their resistance to change. And I'm very concerned about what's just been passed about conducted energy weapons. I hope that people are going to be watching this. Ms. Carroll is absolutely right. We can't wait for any yearly report. We need to see that fairly quickly. I'm very concerned about what's
please wrap up.
happened. Please read what I've handed out
Yep.
and consider it. I would be very grateful. I feel that in the past you haven't read perhaps what you've been given, and when you put all the pieces of the puzzle together, it is extremely troubling. Thank you very much.
Yeah, thank you. Any questions? Yes, Mr. Jeffers.
In the Way Forward report, it speaks to the question of evaluating the performance every 3 months.
Yes.
Have you used that facility to do that in any way?
I have tried my best. I've tried to be very cooperative. I have met with a high-ranking officer at the local division, and I see absolutely no difference. Also, these newspaper articles about what's happened, I don't know of what's going on in the force in general, but the newspaper is just filled with problems.
Yeah, but the thing is, the reason I'm asking that question because it addresses the question of neighborhoods or coming
Yes.
together
Yes.
and having this discussion and observations that you have made.
I have attended a number of meetings with other people in our neighborhood, and they've brought up problems, and basically those that have brought up problems have been ignored, and those that have given compliments.
How have they been ignored, if you don't mind? In what way?
Well,
Like,
a specific person, somebody that I very much admire, brought up some questions about the things that I've handed out to you. And she was told, these are the newspapers trying to sell newspapers. They make up stories. The newspapers make up stories? Well, then go sue them if they make up stories. I don't see the newspapers making up any stories that I know of. No one's brought that to my attention, but that's how she was handled. This is somebody very young and healthy that belongs to a number of things in our community, things that I used to do when I was much younger, and that's how that was the response she got. Newspapers are trying to sell their newspapers, they make up stories. So I don't know what to say, but something is wrong. There's a disconnect somewhere. There's no negotiations going on between the police board and the union. If there was, people wouldn't be standing outside confronting our chief of police on Family Day instead of just coming in and making an appointment. We'd like to speak to you in private. We don't need to stand outside. Excuse me. For some reason, I've decided to have a coughing fit like Miss Carroll. So basically what really bothers me is this, everything's done in public now. Someone suggested to me, someone that you know very well, suggested I buy myself a new phone with a camera so I can record everything I say and do with the police and send it out over a computer so that I'm not the lone voice in the wilderness. And I thought, well, I don't know, are we in the twilight zone? I'm feeling disturbed about what has happened. A vote against our chief of police, our Chairman Pringle, having to start the meeting by saying he wants everyone to know that the board is behind our chief. This is our new chief of police. He hasn't even been the chief of police that long. And already we're having a vote on getting rid of him. Well, we haven't even really seen what he's going to do. He's been ill. He just came back recently. I feel overwhelmed at what's happened. I had such high hopes for the way forward, especially, I know you all know Shauna Coxon. Well, it was my honor to meet Shauna Coxon when the chief of police and other members of the board, one being Mr. Pringle, went around to meet the public. And that's where I met our new deputy chief, Coxon. And we just had a word before the meeting started about we got along so well and we were speaking with each other and everything was going along well. And then suddenly everything seems to be falling apart. Not between me and Deputy Chief Coxon, but other things that have been decided that we all had high hopes for seem to be crumbling. And no better example than what I've just handed you and what just happened here in the last week, right outside our own police headquarters. I feel that somewhere things aren't going well. Command does not take responsibility. They talk like they do. But I would have been outside, instead of standing outside talking to them, I would have said, I'm the chief of police, come on inside, what's your grievance? I wouldn't have allowed this to go on, that people think they can come here and confront him like he's nobody. He's the chief of police. This is the Police Services Board. I come here because I want you to listen to what I have to say. Our families had problem after problem after problem with this same division, and there's no end in sight. I cannot believe I'm still getting the same treatment that I got how many years ago? Daily, it's the same story. And now these newspaper stories.
Okay, please wrap up.
Any other questions? Thank you so
And
much.
I'd like to thank you for your deputation.
Thank you very much.
Yes.
I hope to see you all at the
next
next meeting.
deputant.
Thank you.
Dion Renee. Okay. Dion is not here, so okay. So received report, Councillor Carroll, Mayor Tory seconder, all in favor, any opposed, seeing none, carried. Item 10, we have deputation, and the deputant is Dion Renee. I don't think she's here. So at this point, I'd like to ask for a receipt. Councillor Carroll, Mayor Tory, all those in favor, any opposed, seeing none, carried. Next, we come to item 14. The deputant is Dion Renee, and I don't think she's here. So this one is to approve the recommendation. Councillor Carroll, Mayor, Mr. Jeffers, all those in favor? Any opposed? Seeing none, carried. Item 15 is the annual report, 2017 parking enforcement, and we do have a deputant, Mr. Derek Moran. Please take a seat, and you know you got 5 minutes.
Notice of mistake. The Crown is the surety for Mr. Derek Moran, the person I have. So it's going to be a little awkward, but take notice. I have very good reasons to believe that Vice Chair Councillor Chin Lee has now created a conflict of interest for himself in remaining a member of the Toronto Police Services Board, having recently seconded a motion introduced by Councillor Norm Kelly of the City of Toronto on City Council requests Revenue Services Division staff in conjunction with legal services and IT services to review the possibility of utilizing cryptocurrency as a form of payment for municipal property taxes, utilities, parking violations, and municipal land transfer taxes, as well as a payment system by the city, and report back to the Executive Committee in the second quarter of 2018. The problem with all this is For those of you who don't know, the Toronto Police Service have a financial crimes unit. The financial crimes unit, unlike Chair Pringle, have their own Twitter account. Guess what the Toronto Police Service's financial crimes unit just tweeted the other week? Talked about Bitcoin here, and it mentions cryptocurrencies are almost a perfect vehicle for scams. I don't know that one way or the other, but like this is from the Toronto Police Service's own one of their Twitter accounts. I don't think the Financial Crimes Unit was promoting the use of cryptocurrencies with this right here. So I want to know, are the Toronto Police going to help the City of Toronto facilitate this scam upon the people of Toronto? Why doesn't the City of Toronto, instead of reviewing the possibility of utilizing Coinbits and the chain block as a form of payment for parking violations, why doesn't the City of Toronto focus on complying with the statutory rule already in place for them in the City of Toronto Act with Section 336, which they have a shorter version of this in the UK, which makes all this more easier to understand? Take notice of Section 79.2 of the UK Local Government Act of 1888, which says, incorporation of county council, all duties and liabilities of the inhabitants of a county shall become and be duties and liabilities of the council of such county. Now, at his recent budget town hall meeting, when I brought this up with him, after the meeting had ended, the federal MP for my area, Marco Mendicino, parliamentary secretary to the Attorney General, said to me with a grin on his face, "Oh yeah, I know about usufruct. Anyone here ever heard of usufruct? There's duties attached to that Chief Saunders is to take notice of. Usufruct is a civil law term. It's defined as the right of enjoying a thing, the property of which is vested in another, and to draw from the same all the profit, utility, and advantage which it may produce, provided it be without altering the substance of the thing. Then there's the duties that come along with usufruct, which anyone can go online and look up for themselves in Bouvier's Law Dictionary, 1856. This is a definition for usufructuary. Domat, with his usual...
Can you stick to the point? I mean, this is about the parking enforcement unit.
Right, and so we were granted, we have dominion over all of the earth. It says in the Law of Nations, I probably won't get to it. Well, this is, no, in the police officer's manual, it talks about the Law of Nations. And it says the former name given to public international law in the police officer's manual. This is what it says from Vattel's Law of Nations, Book 2, Section 132, Innocent Passage. The opinion of the Burgrave of Nuremberg deserves to be mentioned. God, said he, had created heaven for himself and his saints, and has given the earth to mankind, intending it for the advantage of the poor as well as of the rich. The roads are for their use, and God has not subjected them to any taxes. Now, someone got it into their head a long time ago that it's okay for our public servants to charge us money to park on something we were given dominion over. So that's where the usufruct comes into. I'm just letting you know, Councillor. Now, where was I? Points out the duties of the usufructuary, which are 1, to make an inventory of the things subject to the usufruct in the presence of those having an interest in them. 2, to give security of the person, Section 7 of the Constitution, for the restitution when the usufruct shall be at an end. 3, to take good care of the things subject to the usufruct. 5, to keep the thing in repair at his own expense. And the best part, 4, I left at the end, to pay all taxes and claims which arise while the thing is in his possession as a ground rent. And I think you might remember from Public Works and Mayor Tory, what's that? 5 minutes, oh, I thought you said 1 more minute left.
I said a minute left, so you got 38 seconds now.
Okay, so
35.
I mentioned this to Mayor Tory at the Executive Committee, that the definition of taxes also includes fees and charges in the City of Toronto Act. So when you go around charging people to park on land we were given dominion over to begin with, that's a fee, that's a tax, that's a charge. That's where the usufruct kicks in. And I didn't bring it, it doesn't help that I forgot it, but parking tickets used to be paper-wise. And if you turned it these ways, the yellow ticket actually had the corporate creditor identification number on the bottom of it and the number 96, which identifies it as a credit item remittance.
Any questions of the Deputant? Thank you very much, Mr. Moran.
Take notice, the Crown is the surety for the person, Derek Moran, I have. Usufruct.
Thank you. And I need a motion to approve. Councillor Carroll, Mr. Jeffers, all those in favor? Any opposed? Seeing none, carried. And we have one more item and a new business by Mayor Tory. Okay.
16, deputations.
Oh, it's there, oh yes, 16, sorry. I missed 16. Okay, 16, there's the annual report, 2017 statistical report on municipal freedom of information and protection of privacy and request for additional disclosure analyst positions. The applicant is Paul Cozy. Is Paul Cozy here? Okay. I thought it was a written submission, but I guess you're here. So you have 5 minutes.
Thank you. Good afternoon. My name is Paul Coetzee. I've lived in Toronto all my life, and I'm a retired lawyer. Certainly the starting point for the consideration of the report that you now have in front of you has to be what the law is. The clearest statement of the law that I've been able to find is contained in a letter that was written by the Information and Privacy Commissioner of Ontario to Chief Saunders on May 22, 2015. Quoting from that letter, as set out in the Municipal Freedom of Information and Protection of Privacy Act, the TPS has legal obligations to respond to information requests in a timely manner. As a reminder, under the Act, it is the TPS's duty to, first bullet, within 30 days of receipt of a request, make records available, deny access for written reasons, or justify an extension of time. Excuse me. Second bullet, inform the person being denied access of his or her right to appeal to our office within 30 calendar days. Continuing to read from this letter, it is clear that the TPS is not meeting its obligations. The clear legal starting point when it comes to the Act is that the TPS is not complying with its legal obligations. To use the vernacular, the TPS is breaking the law. Let me talk about two things that have not been given to you in this report by the TPS. Here's the first one. When a requester does not receive the required reply within 30 days, that requester has a 30-day window within which to initiate a procedure with the Commission to force the TPS to comply with its legal obligations. That requester has to fill out a form, supply supporting material, pay a fee which is not refundable. Why does this requester have to go through this time, trouble, and expense? Because the TPS has failed to comply with its legal obligations. Now this form arrives at the Office of the Commissioner. The Commissioner appoints an employee to brief himself or herself as to what's going on, to deal with the requester, and then to deal with the TPS. This is taxpayer money, the Ontario taxpayer money that's being spent, in my opinion, wasted. Why is this happening? It's because the TPS has failed to comply with its legal obligations. And now this request, it's actually at this point called an appeal, arrives at the TPS. The TPS then has to take an examiner and have that examiner, or analyst, or whatever the term is, spend time and effort in dealing with this matter. Why does that happen? Once again, it's because the TPS has failed to comply with its legal obligations. In other words, this is a self-inflicted injury. It would only happen because the TPS has failed to comply with its obligations to begin with. In 2016, there were 17 such procedures. Now, here's the second thing that the TPS is not telling you in this report. If, in my hypothetical, the requester does not file this procedure with the Commission, after 30 days, the requester loses all legal rights to force the TPS to comply with its legal obligations. In other words, the TPS can take as long as it wants to reply or not reply, do whatever it wants. The TPS has given you no statistics about this, but I'm aware of one situation that I want to draw to your attention. A requester on May 5, 2015, sent a request to the TPS. On May 9, 2017, 2 years and 4 days later, the first communication that this requester received was a letter from the TPS asking if the requester was still interested in receiving a reply. 2 years, 4 days, no reply. In 2017, there were 1,235 such situations where requesters lost their legal rights. In my opinion, when I look at this number, and when I look at the number of self-inflicted injury requests that I talked about, I think that this is quite possibly fertile grounds for a class action suit against the board. The Toronto Police Service has a sacred trust of keeping the law in Ontario. If the board approves this report as it is, without a change, in my opinion...
40 seconds remaining.
I'm sorry, how much time?
Just wrap up.
Oh, sorry,
40,
I apologize.
30 minutes. 30 seconds.
That's
sorry,
okay, I'm
30
getting near the
seconds.
end. Yeah. If the board approves this report the way it is, the board is sending the message to Torontonians that there is a double standard when it comes to applying the law in Toronto. The TPS can force Torontonians to comply with the law, which is a good thing, but Torontonians cannot force the TPS to comply with the law, a bad thing. I'm happy to answer questions.
Thank you. Councillor Carroll?
So I'm wondering if you think there's something else behind it, because the report does recommend hiring 3 new analysts because of the backlog and to try and catch up with the demand, because we sort of jumped from 3,000 to 5,000, and it's now been 5,000 plus on a regular basis. So they are adding 3 new staff and making permanent the clerical support to help that analyst staff. Do you not think that would address the problem, at least in part?
If I were a board member, this is what I would require the TPS to do, to come forward with a credible, viable plan 2 meetings from now as to how it's going to comply with its legal obligations. This report says nothing about complying with its legal obligations. It's just a request to hire some more people. And if I were a board member, I would require the TPS at the same time to inform the board as to the number of self-inflicted injuries of the type that I described occurred in 2017, and continue to do that for as long as the TPS is not in compliance with the law. I would also, I'm sorry.
Oh, sorry.
May I make
Yeah.
one more point, or I don't mean to
okay.
interrupt?
That's okay. Yeah. I'm mindful. I don't want to keep my colleagues too long. I hear that concern. So what I'm going to do is when we go to questions of staff, I'm going to give them a chance to speak to compliance, because you can't ask them directly. So I will do that when we get to questions of staff. Board members can ask staff, does this additional staff bring you into compliance in your view? I'll ask them that question when I have the opportunity.
That's fine. Compliance has to be 100%. That's what the law says. There's no exemption in the Act for the Toronto Police Service. It doesn't exist. The Act doesn't say that the Toronto Police Service should try in 80% of the cases to comply with the law. The Act says it shall. Shall. That's compulsory.
Thank you. Any further questions? Seeing none. Thank you very much.
Okay. Thank you for listening to me.
Cozy. Next applicant is Derek Moran. And Mr. Moran, please stick to the point. Thank you.
Notice of mistake. My mother didn't name me Mr. The Crown is the surety for Mr. Derek Moran, the person I have. And as a lawyer, sir, you might want to ask Councillor Carroll where exactly it says that you can't ask questions when you come here to address your public servants. That doesn't exist also. The Municipal Freedom of Information and Protection of Privacy Act. Oh, by the way, the whole stick to the topic, you know, Chris Langenfeld was in court on Tuesday against the board and Chief Saunders, and freedom of expression came up an awful lot. So what you may have said could be construed as a violation of my guarantee, a Section 2.b of the Constitution, which guarantees my freedom of expression. Municipal Freedom of Information and Protection of Privacy Act. Now, I just want to make sure that all of you people haven't taken for granted what exactly the word freedom means, because I find it ironic that if you want to do a Freedom of Information Act, I've never done one here at the police board, but at City Hall, they charge you $5. To me, that's the opposite of free. So take notice of the use of the word freedom used in this title, as freedom is defined in the Dictionary of Canadian Law as one, in a broad sense embraces both the absence of coercion and constraint and the right to manifest beliefs and practices. Freedom means that, subject to such limitations as are necessary to protect public safety, order, health, or morals, or the fundamental rights and freedoms of others, No one is to be forced to act in a way contrary to his beliefs or his conscience. Freedom can primarily be characterized by the absence of coercion or constraint. If a person is compelled by the state or the will of another to a course of action or inaction which he would not otherwise have chosen, he is not acting of his own volition and he cannot be said to be truly free. Coercion includes not only such blatant forms of compulsion as direct commands to act or refrain from acting on pain of sanction. Coercion includes indirect forms of control, which determine or limit alternative courses of conduct available to others. That was RV versus Big M, Drug Mart, 1985, Supreme Court of Canada. 2 is defined by determining first the area which is regulated. The freedom is then what exists in the unregulated area, a sphere of activity within which all acts are permissible. It is a residual area in which all acts are free of specific legal regulation and the individual is free to choose. R versus Zundel, 1987, Ontario Court of Appeal. Now, I don't know if anyone's ever noticed, but the word free is actually in the word freedom. Take notice of the definition of the word free in the Dictionary of Canadian Law. 1, in the context of Section 121 of the Constitution Act 1867, without impediment related to the traversing of a provincial boundary. Murphy versus Canadian Pacific Railway, 1958, Supreme Court of Canada. 2, when applied to any goods described in Schedule 2, means that the goods may be imported and taken out of the warehouse for consumption in Canada without duty. Custom Tariffs Act. 3, without impediment. 4, without cost, right, $5 for Freedom of Information Act request. 5, without limitation. That's ironic, isn't it? The words municipal and freedom being used together like that. It's an oxymoron like sovereign citizen or natural person, because, I've presented at the board here before that, slavery is only created under municipal law and all. So it says in the MFIPA Act, purposes 1, the purposes of this act are A, to provide a right of access to information under the control of institutions in accordance with the principles that 1, information should be available to the public. 2, necessary exemptions from the right of access should be limited and specific. And 3, decisions on the disclosure of information should be reviewed independently of the institution controlling the information. And B, to protect the privacy of individuals with respect to personal information about themselves held by institutions and to provide individuals with a right of access to that information. Obligation to disclose, Section 5.1, despite any other provision of this act, a head shall, you just mentioned shall, as soon as practicable, disclose any record to the public or
1 minute.
1 minute?
1 minute.
Or persons affected if the head has reasonable and probable grounds to believe that it is in the public interest to do so, and that the record reveals a grave environmental health or safety hazard to the public. Notice, however, how there was a distinction made there. Disclose any record to the public or persons. Not public and persons, not public or persons, one or the other. In the Municipal Freedom of Information and Protection of Privacy Act, take notice that record means any record that is capable of being produced. Regulation 823(1). A record capable of being produced from machine-readable records is not included in the definition of record for the purposes of the Act if the process of producing it would unreasonably interfere with the operations of an institution. So it seemed that a properly processed FOI request involves being capably producing the document that was requested.
Any questions of Mr. Moran? No? Okay. Thank you, Mr. Moran.
Oh my God. I'm going to have to say this every time. Take notice, Vice Chair Lee. The Crown is the surety for Mr. Derek Moran, the person I have.
Yes. With that, I'd like to... questions? Or, okay.
Quick question.
Staff.
Yeah, it's a question of staff. So I did note a long time ago, I did note in the report that adding the staff would help us catch up the backlog and get to the point where we would be able to guarantee at least 80% of compliance within the time frame. Does that bring us within the law, or are we still vulnerable at 80%?
The law, as Mr. Kotze pointed out, is 30 days for all requests. The board did direct a long time ago in 2005 that we try to at least achieve 80%.
Yeah.
Hiring additional staff as well as clearing the backlog with some temporary staff will allow us to do that. But we're also using and have automated a tracking system, which will add greater efficiencies. And so we are moving and want to move beyond 80%. We didn't want to ask for more right now until we see what we can do with these additional staff. Once we make that determination, we'll be reporting back to the board. But we want to at least achieve 80%.
And in the past, where to the 20% that remain, policing is a good example of one of those. Revenue services is another where you have a case where they're asking for an unusually large amount. That's what fits into the 20%. Where it takes longer than 30 days just to access all the information, we generally are able to say in court, this was an unusual request, and we did our best to comply. Or we'll at least get to that level?
Yes.
Okay, thank you. I'm prepared to adopt.
Not yet, Mayor Tory. Oh, you don't have a question? Okay. All right, to adopt, Councillor Carroll, Mayor Tory, all those in favor, any opposed, seeing none, adopted. And I think we have one new item that the Mayor Tory wants to introduce.
I do, and I'll be brief, although it's a very important matter, Mr. Chair, but it's the first of, I think, probably a number of things that we'll end up doing on this matter over time. I'm speaking of the heightened and very strong degree of public interest there is with respect to missing persons in the city and how they've been dealt with. And I'm aware of the fact, and part of my motion that I'm going to put up, there it is up there now, so you can have a look, and I think it's been circulated. It speaks to the question of an internal review the chief already has underway, which he's publicly disclosed. And I have, there's concern through the community about this and making sure we're doing all that we can, obviously, to make sure that people who go missing are found as quickly as possible. And I should point out that of the thousands of instances each year that the police service is confronted by when it comes to missing people, the vast majority, I'm talking high 90s%, I think, are actually successfully resolved. And I think that's an important thing to take into account. But there are some that are not, and there have been some recent incidents of in a number of areas that have at least caused people to question, how things happened within the context of current policies, and obviously they've suggested that there may be the opportunity to improve those policies and make them stronger. And so part one of my motion, and I have discussed this in advance with the chief, requests on behalf of the board that when the internal review is available, and this is an internal review that the chief initiated on his own and not at the request of the board, but we are requesting that at the time that the internal review is completed, that it be made public. He has, I don't want to put words in his mouth, but he's responded favorably to that, but I put the words in here that obviously acknowledge the obvious, which is there may be legal or statutory or other kinds of constraints that require some of the information that's in an internal review to be preserved as confidential in light of legal requirements and other things. The second thing that is responsive to, I had in my office, for example, and it's not confined to this, but I had in my office a meeting of about a dozen of the leaders of the LGBTQ2S community. And they have a particular concern about this in light of some recent events. And they are seeking an opportunity to have some feedback, some opportunity to be heard with respect to some of their concerns about missing persons, and really not in a specific way. They ultimately would like to see that, but they understand the fact that there is there's going to be a trial, there is a continuing police investigation, or more than one, with respect to some of the matters that gave rise to their concern, some tragic matters that gave rise to their concern. And so what I have tried to articulate here is a means by which, at the earliest possible time, knowing that a more complete kind of examination of this may not be possible until the trials and appeals are over, which could be a number of years, so as not to prejudice the results of any of those investigations or trials or appeals, that we could have an opportunity, once the internal report is made public, the internal review report, that we could then provide for the board, that is, for the establishment of a process where we can receive community feedback on the internal review and on the broader matter of missing persons investigations, but not on the matter, obviously, of specific cases. and that the results would then be reported back to the board within 120 days of the time when the internal review report is made public. So it gives essentially 4 months, during which time we can oversee a process, we as the board, to go and get feedback on the internal review report and on the general concerns that exist. And I think it just means that rather than saying to different parts of the community, in particular, including the LGBTQ2S community, that you might have to wait 4 years to have an opportunity to express some concerns and help shape any improvements to policy or whatever, that they would have that opportunity sooner. And then the final sentence of Part 2 simply says that after the receipt of this public input, the board could consider at that time whether there's anything that the board should be doing in respect to this matter or not, depending on what input is received. And so it really is, to me, a way in which we can get started on allowing people to both see to the greatest possible extent the work that the chief and his colleagues have done in terms of examining how missing persons investigations are handled, and secondly, get some feedback on that so that we're not saying to people who have very deep concerns about this that they would have to wait potentially a number of years to have any opportunity to be heard. And I think this will go some distance to allowing that to happen. And I think the chief is satisfied that this can happen in a way that will be orderly and responsible. So that is what I'm moving, and those are the reasons behind it.
I have a question for the mayor. Yes. What timeline are you looking at for them to complete the review?
Well, the chief is, he could answer that. He said to me he's going to obviously get it done as soon as possible, but he may have a better idea as to when.
That's why I'm asking, because I remember that in May, there was a reputation on engaging the community when somebody goes missing.
Yes.
And we're still waiting for that report to come back to review to see how we engage the community to find somebody faster.
Yes, and I certainly recognize and appreciate the issues and concerns, which is why on December 4th I publicly made the declaration that we need to have a review. I hope that there's an appreciation that we have on average 4,000 missing people occurrences every year. So Toronto has a unique issue when it deals with capacity, but nonetheless it is still taken and considered seriously. There are some legal implications that are affecting the timeline with respect to court processes that are in progress. With respect to in order to do this comprehensively, we have to work with other agencies, and I can't control those timelines because those other agencies have to dictate their own actions in accordance. But I do want to make it clear for the record that I do want to take an approach to expedite the findings as soon as possible, and what I can disclose in a timely fashion so that you're not looking for this complete package with ribbon and bows. If certain things are identified that need to be identified and discussed and changed and altered, then those actions will be taken by my service.
Thank you. And Mayor Doris' motion, Councillor Carroll second. All those in favor? Any opposed? Seeing none, carried. Motion to adjourn. Mayor Tory. All those in favor? Any opposed? Seeing none, adjourn.